gonna take it slow. But I'm loving you. Take it slow. I'm loving you.
Good morning, everybody. It is Monday, July 29th. Oh my gosh, where has July gone? Oh, I don't know. July has flown by and it's going by. We are almost at the end of the month. The Olympics have started. I will do an Olympic medal count at some point in the day today. And then we have today, we're continuing to watch the Black Swan murder trial. And we ended the day yesterday, or Friday, not yesterday, with the Black Swan herself, Ashley Benefield, up on the witness stand. And that was a little bit bombing. That was interesting. Very interesting. I don't know how today's going to go. We'll see. I've got my cup of coffee. I'm AdaKay, and welcome to my channel. Y'all, we're going to have a good day today. Yes, we is. Oh, I got to find it. There we go. Let's get started. Hey, y'all, I'm AdaKay, and I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Well, good morning. And we also have birthdays. Oh my gosh. We got a lot of birthdays today. Good morning, Miss Morales. Good morning to you. All right, here come the happy birthdays. I'm not going to do it so loud this morning.
Birthday to you. Happy birthday to you. Happy birthday. Happy birthday. Happy birthday to you. Happy birthday.
Happy birthday, you guys. We have a lot of birthdays today. We have happy birthday to Miss Denise. Happy birthday. Y'all go put money in her fundraiser for Alzheimer's Association. Cindy, happy birthday. Neela, happy birthday. Joan and Verna, oh my gosh, y'all have a happy birthday. Robin, happy birthday. Blessed birthday. Breaking Betty, happy birthday. And she too is raising money for donations for the River City Advocacy Program. God bless them. Dylan, happy birthday. Cindy, happy birthday. Leanne, happy birthday. And Miranda, happy birthday. Happy birthday. Happy birthday. We got it all in. Hallelujah, hallelujah, hallelujah. Oh, take a breath. Get the coffee. Work out the kinks. Oh. I hope y'all had a good morning. I hope you had a good weekend. I struggled this weekend. I've got a crick in my neck on this side right here that just will not go away. I don't know why, but the crick won't go away. I've tried heat, I've tried cold, I've tried everything, and it's better than yesterday. So I'm grateful for that. So today, the defense is continuing. If you don't know anything about this trial, let me catch you up. So Ashley met Doug Benefield. She's 24 at the time. He was 54. And they had a 13-day whirlwind romance. Then they got married. And of course, they moved in together. And she wanted a ballet company. So they sunk millions into a ballet company. Hi, VS King 07. How are you doing on Twitter? Thank you for joining. And then she decided that she wanted a baby, but he couldn't because he had a little snip, snip, snip. So she convinced him to get it reversed. She paid for it. It was reversed. And they had a little baby girl. And about 2 years later, between all that time, now she says the moment she came back from her cruise with her mom and her girlfriend right after they were married, from that point on, he was jealous. Oh, I forgot. She was jealous and he was jealous and beginning to be controlling and abusive verbally. He said he never physically did anything at that point, but very verbal. And then things just progressively got worse. And so she moved in with her mom when she was pregnant because she got morning sickness and she was just sick all the time, just super sick. And she started accusing him, even when they weren't even together, of poisoning her with heavy metal and the unborn child. She got a restraining order, was reported. It was a hot mess. Then she had the baby early, like a month early, and had them induce her because she kept saying that she was getting poisoned and she was concerned for the unborn baby. So she was induced early. He didn't even know he had a child for 5 or 6 weeks. After the child's born, of course, he's fighting for his rights. He wins visitation. And long story short, they get back together. Not living together, but visiting, talking, dating type relationship. Going places with the baby, doing things. And then they decide to move to Maryland. And she was saying that he was going to have his house. She was going to have her house. He was saying to the therapist they're moving in together. She didn't have the heart to tell him they weren't moving it. It's a hot mess. Long story short, the day they were packing up the U-Hauls, she asked him to pack all his stuff in the back, all hers in the front. Well, all his in the front, all hers in the back. So hers they could get off first. They got in an argument in the house. He allegedly slapped her for the first time and blocked her from leaving and was wailing his arms around like karate. And she shot him in self-defense. She feared for her life and shot him twice. She shot more than twice, but 2 bullets hit him. And then she runs to the neighbor next door. They call the police, and that's where we are now. We're here. We're here. So, yep. I sent it to you, darling. Oh, I heard the ping. She's here. Or she's coming. I thought I heard the ping. Except my interpreter. It's early. Later for her, early for me. Oh, here it is, love. Yeah, it's a little later for her, early for me. The Olympics little mascot. What the heck is that thing supposed to be? Have you guys seen it? Looks like a red blob. Looks like a red blob. Don't know. That's interesting. So I'm trying to think. Anything else happened over the weekend? Who's an Olympic junkie? I used to be. I still like to watch it, but this year I'm not so into it. Just not. Okay, let's look at the Olympic medal count. Here we go. I don't want to do it that way. Let's do it this way. China has 9, Japan has 8, Korea 7, Australia 6, United States has 12, but they're listed in under 5 because they only have 3 gold medals. We only have 3 gold medals, but we have 12 total. Choices. Okay. So gold medals, China 5, Japan and Korea 4, Australia 4, United States 3. But right now, I think the United States has the most overall medals at 12. And the next highest is 9 with China. Japan is 8, 7 is Korea, and 6 is Australia. So overall medal count, we are winning overall medal count. Okie dokie. That's good to know. I think court has started. I don't know why my thing paused. It has. Let me share stage. Make sure volume is turned up. Let's see where they are. They're at sidebar. Still waiting for court to begin. I'm waiting for interpreter to pop in. Y'all, if you guys can please, I'm sharing it on Twitter, Facebook, YouTube, Twitch. If you guys can please share this with your community you're in. We're interpreting this because the deaf and hard of hearing don't usually get access. Oh, here I go. The Yannis don't usually get access to such things. And so it's important to me that that they get my channel is 4. Oh, okay. It's just some awards. That they get access. It is important to me that they get access. Very important. Very, very important. So we appreciate it. Good morning. Listening in the car. Thank you. I know that's hard. Thank you so much. I pray little one's doing better today. I guess I should get my binder open and ready. The Yannis have hit. The Yannis have hit. Warning, warning. I need a Yannis have hit button. Oh. Monday mornings are so hard to get in the groove. I should have came in here yesterday to get in the groove. And my glasses. Oh my gosh. Y'all, I'll be right back. I left my glasses. Dag nabbit. Let me go get my glasses. Be right back. I can see, said the pretty cat. I got this little pillow. Isn't it cute? Just for my back. Not that I have to have it, but it's nice. Oh, that's too comfortable, y'all. Too comfortable. So anyway, Miss Jules is in court. Good morning, Miss Jules. I'm going to tell her good morning. Glad to see her in court. Good morning, Miss Beautiful Jules. Glad to see you in court. Period. Hope you feel better today. Period. Look forward to hearing from you. Stay warm. Let's see if she'll respond because I can see she's on her phone. She's got that position. Either that or she's writing something. I did some technology rearranging and I think I'm really liking it. I just got to find my new place to set my coffee. Okay. Oh, I want to sing that. I love coffee. I love tea. I love the job and it loves me. Coffee and tea and the job and me. A cup. Oh. I know, I'm getting medicine, guys. Sorry. My kids say, Mom, why do you keep your medicine in here? And I said, because I'm here at the same time every day. I am here at the same time every day. Oh, the judge has a techie. Is that what we're waiting for? The judge has a techie. Oh, someone asked me, how did I like this judge? And where do I stand on this case? First of all, I love the judge. Love the judge. And where I stand on the case, I don't really share that personally until the end of trial. But I can say this. Either one, she's guilty and plotted it. Two, I thought she was picking her nose. She's got a finger in her mouth. She's fully innocent. Or three, we all know she shot him. But we're talking intent. Three, I think that he was abusive, but her reaction does not meet the reasonable reaction for the situation. What would a normal, reasonable person do in that situation? I don't know. So those are the three ways to go. We just saw Eva.
All right. Good morning, everybody. We're back on the record in state. This is actually Benefield 2020 CF 3014. Thank you for your patience as we've gotten started this morning. First thing, we had early this morning, a juror call in that there was some car trouble. Juror was running late. My understanding is all the jurors are here and they've been brought up. And then obviously I've had computer problems this morning. So we'll just get going. Anything you need to bring up before we resume with the defendant's case in chief?
Judge, the clerk notified me on Friday that we had not actually entered states 103 and 104. So I would like to go ahead and enter those. I don't know if the defense has an objection. We can do it in our case in rebuttal if we need to, but we did talk about them during testimony. I just didn't say the magic words.
I just don't know what 103 and 104 is.
It's
I don't
the
either.
modeling picture and the mugshot.
Oh, actually, yes, we do have something to say about that.
I'm sure you do.
All right. So you're just going to save that until your rebuttal? Okay.
Yes, and then just to put on the court.
There's a discovery issue with respect to those two photographs. We were never provided them.
Well, the mugshot.
All right. So I'm making a note that we have to have a Richardson hearing on that issue then.
And also just to, for scheduling purposes, at some point, hopefully before right at lunch, I would like to have a discussion about whether the court would allow the state to introduce evidence from Dr. Broder that we had previously talked about before. I just wanted to get a ruling from the court so I know whether to get him here or not.
Y'all pray
Okay.
for Braxton. He's starting his job
I
today.
don't know what evidence it is, so I'll just wait for you to bring it up.
Good morning, Andriel.
Defense, any issues before we resume?
No, sir.
All right. State, you ready?
Yes.
All right. You said ready.
Yes, sir.
All right, just want to make sure. Are you feeling all right?
Yeah, picked up a little cold, but I'm good.
Same here. So I understand. Okay.
Watch them all have COVID tomorrow. Court delay. Oh God, that would suck. It has happened. Okay, Eva, little Eva. I know I was hard on her. She is very young. I watched a video that she put up on Twitter, and she is driving from South Carolina to Florida for this trial. She is also involved in another lawsuit where she is suing a company over her clothing brand. It's a brand issue that she's suing over. And she has had to spend the last 3 months of all of her income, so she's not had a paycheck. She is learning what it's like to be a business owner. I'll tell you that. That's what's happening there. But we were hard on her. And I understand that some people were not happy
All
with
right, you all can have a seat. Welcome back, everybody. Good morning. I don't know who had car trouble, but I hope everything worked out and you've had time to kind of calm down from that. So we're going to get started. And when we left on Friday, the state was presenting its, the defense was presenting its case. I do need to ask you though before we get started, because we just had a couple of days off. Did anybody discuss the case amongst yourselves in any way? Did anybody discuss the case with anyone outside of this jury? Did anyone do any research or watch any coverage at all about the people, places, things, or legal topics we've heard anything about? Everybody says no. Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Bruce Ferris.
Bruce who? Ferris. Expert witness. So we're going to have about an hour of him trying to get him qualified as an expert witness. No, God, our new one's up.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Morning, Judge.
Morning, sir. My name is Judge White. I'm going to be presiding over this case. Just have a seat, make yourself comfortable in that chair. Get yourself about 12 to 15 inches from that microphone. It's pointed straight up, but it does adjust down, left, right.
Okay, we're going to take a quick break. Okay, I have to thank my fabulous mod boss because she helped me create all of these fabulous emojis for the members. If you are a new member, guess what? Y'all have your own special emojis, y'all. You do. And I'm so excited to let y'all get to use them. We have multiple ones. I got to remember which ones they are, but I have something. My mod boss is driving. She can't see it. But if you can see your phone, mod boss, this is for you. Hey, y'all, I want to give a huge shout out to my favorite mod. Nah, just kidding. All my mods are my favorite, but she's my right-hand mod, and I call her my mod boss. Her name is Miss Kevin, and I just want to say, girl, I couldn't have done this without you. Love you, and I look forward to many, 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 many more posts and lives with you. Be blessed And thank you for all you do. Yay! Okay.
Up, down, whatever you need.
You do.
Yep. We love Miss Kevin. You taught me so much, y'all.
Good morning.
Good morning.
Will you tell us your full name and spell your last name, please?
Bruce Eric Ferris, last name Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
And how long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
You're not a
Yes. Been to a lot of trainings, seminars, and certifications, and various conferences. In my curriculum vitae, I'll call it a CV, my resume. There's about 100 items listed of trainings that I've been to over the years.
For what specific field?
In domestic violence and mental health and trauma to children and trauma in general. And I could go on, but that's the general focus of all my work.
Let's talk about your work experience for a moment.
Oh, okay.
Tell us about it, please.
So as a counselor now, my day is spent seeing individual clients. I specialize, like I mentioned, in domestic violence victimization, both men and women. I also see generalized mental health issues and typical things that a counselor would do, but I have a focus on domestic violence and family problems. I also counsel adolescent boys, most of which are going through the foster care system or adoption or divorce of their parents, etc.
All right, and what position did you hold prior to that?
I was a police officer in Gainesville, Florida, for 20 years. I graduated the police academy in 1993, got sworn in 94, and I retired in 2013. The last 10 years of that career, I was a detective, uniquely running. I was a lead detective of what's called the Domestic Violence Unit of the Investigations Bureau at the Gainesville Police Department. Over the course of that time, when I retired, I looked back and did a little search, and I had arrested or filed charges or got warrants on 500 different abusers over those years.
Mr. Ferris, give us an idea of your professional credentials. Lightly.
Sure. I have, I'm licensed with the state of Florida, like I mentioned, as an LMHC or licensed mental health counselor. I have to keep up with education, et cetera, keep my license active. I'm certified as a Batters Intervention Program facilitator. In case anyone doesn't know it, Batters Intervention, which I'll refer to as BIP, is a 6-month class given to abusers who are found guilty or on probation or could be part of their injunction order. And it's a curriculum based upon the Duluth Power and Control Wheel. And it's a psychosexual type, not sexual. It's a type of therapy that involves some counseling and some ownership and learning.
Why do you have
And also I was a certified police officer, I mentioned. I also have certification as a domestic violence danger assessment and level of danger scoring system developed by Jackie Campbell out of Johns Hopkins University. And I also have a certification as adoption competency training, mental health for mental health professionals out of Rutgers University. I'll
All right,
stop there.
Mr. Ferris. And briefly, have you been the recipient of various awards and recognition?
Yeah, I have.
Give us a brief idea.
Okay. The Alachua County Board of Commissioners had nominated me to Governor DeSantis to be part of the Children's Trust Fund of Alachua County. I received the 31st Annual Martha Varnes Award for outstanding achievement in prevention of domestic violence against women. I had recognition for valuable contributions in what's called crisis intervention team. I train officers how to de-escalate confrontations with citizens. I did receive the 2010 Distinguished Victim Service Award for recognition of outstanding contributions to crime victims for National Crime Victims Week by a State Attorney General Pam Bondi awarded that to me, and Governor Scott at the time was there for the presentation.
Mr. Ferris,
I'll stop there. There's a few more.
have you been recognized as an expert on domestic violence in various courts of the state of Florida before?
I have.
Approximately how many?
So I've been involved in 60 some cases as either consultant or expert witness. 50 of those I've been recognized by the judiciary as an expert in domestic violence, mental health, batter's intervention, effects of DV on children.
All right, and when you say you've appeared before approximately 60 times as an expert witness, was it for any particular side in a dispute? That is to say, for example, in a criminal case, was it always for the prosecution, always for the defense?
But both. I worked for the state attorney's office and worked for defense. And a majority of my cases have been in civil court, though I have worked in criminal court also.
Would you, Mr. Ferris, tell the ladies and gentlemen of the jury what another definition of domestic violence is?
Well, so there's the criminal statutes of domestic violence, which are typically, we all know, it's battery, ag battery, assault, ag assault, false imprisonment, sexual abuse, etc., person crimes involving a family or household member against each other. And that has another definition, that's spouses or family members living together, or it could be a couple that had a child together that have never lived together. Doesn't include, let's say, cousins who've never lived together and aren't intimate in any way. But through my experience, I've realized that there's a greater, that's umbrella, and that has to do with power and control. The abuser needs to control their victim. Now they'll use the criminal things, hitting, etc., all those things, but in a greater sense, there's also this, I referenced it earlier, the Duluth Power and Control Wheel that DCF's accepted for the BIP class. I'd like to explain the power and control wheel, if that's
Yes.
okay.
In fact, with the court's permission, we could perhaps have the screen come down and the lights dim. Mr. Ferris, you have a laser pointer in front of you. The little star in red will provide you with
Okay. Judge Max, stand here and pay attention to the mic as I talk.
Any objection?
Okay.
This will be interesting, y'all. This is going to be interesting.
There's the criminal definition.
Was
And
there a question, objection, was there a question?
Go ahead with the question.
yes. What is it that's on the
Right.
screen?
so what
Mr. Ferris,
okay,
Mr.
so
Ferris,
yes,
would you please tell us what is on the screen?
I will. So this is what's referred to as the Duluth Power and Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power and control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating. your partner again to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do illegal things.
Now, I have a couple of questions I'd like to ask you about that wheel that you demonstrated for us. Is this something that you created?
No, this was created by, up in Duluth, Minnesota, there was a domestic violence advocacy group and also researchers, and they looked through police reports, they interviewed victims of domestic violence who come through the shelter, and through a period of time, they developed these 8 items and created the power and control wheel. This wheel is used around the country and actually internationally. Like I said, it's the base curriculum for the Batteries Intervention Program class I talked about, and it's taught quite readily all across America and used by domestic violence shelters, et cetera.
How long has this wheel, if you will, been in existence?
Yeah, probably, I'm guessing 30 years or so, could be a little more.
Are there any agencies within the state of Florida that predicate their decisions upon the Duluth Power Wheel?
Yeah, the DCF accepted the power and control wheel for the curriculum for the BIP class.
That's the Florida Department of Children's and Families.
They
Good
were
point.
the ones who were controlling the BIP class when it started up. Also, a lot of federal money, domestic, against women act, things like that have always promoted the power and control wheel, and also, giving out grants and education money.
Are the majority of abusers male or female?
Majority are male, but there's certainly a percentage that are female. I'd say it's at least 2/3 male at least. And in my practice, I have male victims.
And what about on the other end, the victims of domestic violence? What's the percentage of males and female?
So again, it's always, there's some different statistics. Somewhere between 2/3 and 3/4 are men, and
Are men as victims of domestic violence?
2/3 to 3/4 abusers. So that on the other side of that, they're 1/3 to 25% male victims. And I just got a male victim this past week.
Okay, so
Okay, I'm done.
I want to make sure we're clear on this.
Sure.
You've told us that the percentage of abusers that are male is approximately 2/3, is that
At least
correct?
2/3. There's some statistics to make it actually higher.
Would you tell us, please, what percentage of domestic violence victims are female?
Somewhere between 2/3 to 3/4.
All right. Now, I want to ask you if you would educate us, Mr. Ferris, about whether or not there are common characteristics that abusers share.
And I certainly can do that, Mr. Teller. Can I make one closing statement about the Duluth wheel? and
Sure.
power and control. So I think it needs to be said, maybe I didn't say it, that the whole idea of the use of the wheel is to get compliance by the abuser with their victim. So they're looking to control them, and either they use those criminal, the battery, or they use emotional abuse or intimidation or these different techniques to try to control them. So the victim of domestic violence is placed with wanting to have the least harm to them. So they get into a compliance, I call it equilibrium type of status mode, where they seek to get along, to go along. They don't want to poke the bear. They don't want, they believe that this is certainly a danger to be involved with this person, their mate, their spouse, etc. So they comply, and they get in this compliance mode, and they can certainly appear to society as nothing's going on, but there actually is, and they're afraid to display that because of the retribution that might happen.
All right,
I'll go on from there.
this wheel then is the product, if you will, of the science of domestic violence over the past 30
Right.
years.
And throughout my entire practice, the thousands of people that I've counseled and even the 500s I've arrested, I see this repetitively to be true.
All right. Now, would you please tell us,
I do. Thank you.
I need you to make sure you keep your voice up so that
Yes,
we
sir.
can hear you. Would you now tell us, Mr. Ferris, whether or not there are common characteristics that abusers share?
They can be anyone from all socio-economic stratas, and that's been my experience also. And I said, like I said earlier, predominance men, but also females.
What's the motivation for their behavior or abusers?
They want to control their partners. I find often an ownership type attitude. They want to control them.
How do they treat generally pets in the household?
Pets. So statistics have shown that abusers abuse pets well above average, more than average citizens would. And so I have two theories about that. One is that they're missing some empathy, or they tend to see things as objects. And so,
Sustained.
okay. Can I explain why they abuse pets?
Yeah.
So if a pet is belonged to the female or their partner, the victim.
Judge, I'm gonna object.
Can you approach, please?
Interesting. What do y'all think about his testimony? What are y'all's happy thoughts? I am trying my hardest to get a. Are you ready, Miss Diane? Wave when you're ready. Yeah, he's testifying for her. Yeah. I just, I don't like it when an expert testifies for the defense. Testimony should support the defense. Do you believe his testimony is supporting the defense, or is he testifying for the defense? What is your humble opinion? This pillow does help. I love my chair. It's very comfortable, but my back has not been a happy camper the last 2 or 3 days. I slept funny, I think, Friday night, Saturday morning. Are you ready, Miss Diane? Wave when you're ready. All right, she's here. Good morning.
Good morning. All
Oh, don't
right.
we look so beautiful?
Well, that's what happens when you have a shower and wash your dirty hair.
Put your lipstick on.
Yes. I always must have lipstick. And I really like these earbuds. They look like earrings.
Okay. They look like you got those little big. Okay. Got something for you, Miss Diane. Everybody, if
Yeah.
you don't know, this is our fabulous interpreter. Hey, y'all. I want to give a huge thank you to our wonderful interpreter, Miss Diane. She is a nationally certified American Sign Language interpreter. Diane, thank you so much for interpreting all of our court proceedings and our lives. We love and we bless you. And y'all, throw her some love. Buy her a cup of coffee. In the meantime, Miss Diane, again, thank you so much.
That's lovely. Thank
You're
you.
welcome.
Oh,
You're welcome. On my mind, let's wait and see. Welcome on my mind. I appreciate you being here. Kay Swan, love that you're here too. Of course,
this is a
all of my
special.
Would you
mods
describe
and
for us what the term coercive control means in a domestic violence
Sure.
relationship?
So coercive control, acts of aggression, assault, threats and harm, punish, frighten the victims. And that fits in with creating fear, and it fits in with this whole continuum of power and control, a pattern that is developed to control the victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And,
All right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
Definitely not. Oftentimes, the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever is the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often, when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family.
Why?
Because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we've all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So would that be, could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And
what
if I'm
is the victim trying to accomplish by engaging in the appeasement behavior?
not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again create a type of stasis or minimum amount of aggression. So they don't want to again poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante, we'll speak.
Objection. I have the same objection.
I'll overrule on this one.
So yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the a victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child, even though it's detrimental to themselves.
A couple of questions about abusers, if I may. How do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern? Excuse me.
He's got a cold.
Is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
I can say a very high percentage, well, I don't know, over 90%, I'd estimate, of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone. It's one of the 8 categories is minimizing, denying, and blaming. And it's all a technique that she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury, Mr. Ferris, is there a particular time in these relationships when violence is most likely against the victim?
Yes, very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser, and if the abuser is there. There's a high fatality rate, high incident of danger to them. I've been trained in this in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
Sustain.
All right. I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions.
Certainly.
Involving the hypothetical abuser and a hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. Do you want to approach?
Yes.
Oh, Mama's forgot the objection count. I need to get my count back in order. Oh, yeah. Did y'all see all of our new emojis for the memberships? If you are a member of this channel, you get to use all those fun, cute emojis. I can't quit yet. It's definitely a Monday morning. Okay, well, I've got 2 more objections than they do. Is your wrist hurting, Miss Diane? I'm sorry. Okay.
And piling trash.
So you worked too hard this weekend.
Yes.
You're not supposed to do that.
I know.
You have people, don't you? You got grandkids, don't you? Not old enough for that.
Enough to help.
Not old enough yet. I slept more this weekend Friday, I slept a lot. Friday night. Saturday, I slept a lot. I worked here from 10 to 4, but man, after that, I just go home and crash and slept off and on since
Oh,
7:30, 8 o'clock last night. But it's not restful. It's that wake up every few hours sleep.
not me. When I go to sleep, I crash.
I
And I
wish.
stay asleep unless I wake up to go party. But then when I go back to bed, I crash again.
Yeah, I know. I've roomed with you. You're like out. I'm like, how
Mhm.
do you do that? I'm so jealous. I toss and turn and toss and turn and toss.
I am out like a light.
Mm-hmm. You are. I've never been that way.
I've
Well, I can't say that.
always.
When I was a kid, I think I was.
There was one time in my life, it was like I go to bed and I could feel myself shutting off. It was like switches from my feet up. Click, 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 click. And by the time, yeah,
Your body was checking
uh-huh, yep,
out.
yep.
Y'all, that's crazy. I'm jealous.
That's me. But then I am a very different person.
Oh, hey, Zach, we're missing you. Veronica or Ronnie went fishing with the family. They caught a lot of fish over the weekend.
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim. Cruelty to pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps. Placing a tracker on the victim's car, an illegal tracker. Throwing things, breaking things.
I have to stop there. If they're married and he is a part owner of that vehicle, that's not illegal. If they're married, it's not illegal.
Yelling, screaming, belittling, cursing, humiliating, declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal threats if the victim leaves, more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only absolutely, but those are checklist points right off the Duluth Power and Control Wheel and right off my experience, they're stereotypical abuse techniques.
Right. And now my last question for you, Mr. Ferris, is I'm going to give you a hypothetical. And tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing. Would that be consistent with a victim of domestic violence?
Without a doubt, these are again techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So yes.
Lastly, one other factor I neglected to mention: would a video of the abuser and the abused at a restaurant with the child and another adult, whereby they are all acting happy, be consistent as well?
Well, certainly, if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely. And it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident.
Judge, I'm going to object to non-responsive.
Overruled.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse, to get along sort of description.
My final question, as it relates in general to domestic violence: assume hypothetically there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the earlier accident?
Without a doubt. I've got clients who tell me about.
Yeah, just
so yes, definitely they don't forget the abuse that's occurred to them. Trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Farrell.
State, Cross.
Thank you so much.
This ought to be good.
Hi, Mr. Ferris.
Good morning.
Or not.
Mr.
Okay.
Oh.
I want to ask you give you some examples and ask you if this is consistent with a victim mentality.
Sure.
Minimizing the abuse.
Now you're asking me if the victim would minimize?
Yes. Like what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame.
Yes.
Making excuses for him.
Definitely.
Or her, I guess. But not reporting the abuse.
Right.
Dropping charges if they were filed.
Yep.
Not standing up for themselves.
Yes.
And not leaving.
Yes.
Okay. I'm going to put that wheel back up, and I want to talk to you about the pie sections each.
Sure.
I wish I had that music from Jeopardy. Copyrighted. Oh, can you do this? Oop. That's going to put everybody to sleep. My fingers are hitting the wrong things this morning.
While she's fixing it, and I know you're familiar, and do you have a copy in front of you?
I
do
do
too.
I want right in front of me.
Okay. And so I want to talk first about the use of intimidation, would you agree that if somebody, this says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic
Yes.
if it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse. Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply that to a relationship?
Could you restate the
Yes.
question?
So if in this wheel,
Right.
hypothetically, when I'm talking just about using economic abuse,
Right.
would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically?
Mhm.
No financial dependence on
Mhm.
the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home. Would you agree with me that that's not a situation where there was isolation?
Well, you have to remember, under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor.
Then isolation component may not be part of that, component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thanks. Using the children,
Mhm.
if the hypothetical victim had custody of the child and attempted to terminate parental rights,
Mhm.
and the hypothetical abuser had to seek court intervention to get the child,
Right.
would that be a factor in your consideration of whether children were being used? If she had sole control of the child.
So you're asking me if I could just reframe that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty. I'm just asking if that would apply. We've talked about how these
Right.
things apply.
It may not apply. It would not apply. But I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing
Okay.
it. I'm just asking hypothetical
Okay.
questions. How about the using a male privilege?
Mhm.
If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles. In fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay. Can you elaborate?
Yeah, the men's roles. And when you say purchasing things, I would want to look into what is that a concept of what the role is. I'm the man. I purchase things. I control things for you. I decide what to get, et cetera. So that could be a male privilege issue.
Okay, and I understand that, and that would support that. I think it kind of goes with the economic abuse. And what I should have asked is, if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else? And he is, yes, of course, and he does it. That's what I'm talking about, not him telling her what she may have.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not.
No.
Okay. And so that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
How about minimizing, denying, and blaming? What you said that was present in 90% of the cases.
Quite a bit, yes.
Right. I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong. I lost control. I shouldn't have done those things, and never says it was your fault you did those things. Would you then feel like that's not minimizing, denying, and blaming?
No, I wouldn't agree with that, because it could be that part of the strategy of minimizing could be that I'm sorry I didn't do it. That could just be minimizing.
I'm sorry I didn't do it. I'm sorry I did it.
Right.
That's part of
That's
minimizing?
still, yes.
Well, certainly not denying or blaming, right?
I would need more definitive facts.
I guess I need an explanation on if somebody takes responsibility for accusations against them,
right.
how that is minimizing. To say, yes, you are correct, and I am sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be the opposite?
Yes,
that person
it could
is
be.
taking credit, is taking responsibility for their actions.
Right, certainly it doesn't deny that it happened, that's for sure.
Right,
okay.
And no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors on this wheel.
Right.
And whether or not, if somebody, under my hypothetical, admits to responsibility for the accused abuse and apologizes for that, whether or not you would consider that denying and blaming.
I would need more information on the relationship and the scenario to decide that.
Is there a scenario? Okay. How about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no displaying weapons. I'm sorry. I'm sorry. I'm looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
Well, you gave me a discrete list, but emotional abuse also includes name calling, putting someone down, affecting them emotionally.
I guess, is there a scenario, Mr. Ferris, where you will agree with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say, no,
yeah,
it may not.
Yeah, I can't help you with that. I'm not asking the questions. I know I'm not, you are.
Would you take into account, based on, with these factors, such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, or let me give you a scenario. She does not live with him. She's actually in another relationship, potentially engaged to a new man.
Okay.
She tells him that she does not want to be with him.
Okay.
And she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of their relationship.
I guess, so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern or behavior. It doesn't go on over a period of time in an attempt to control someone. So if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence, but that's it. She's not appeasing, she's not put an emotion, the whole power and control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse? The parties are living apart. They're independently,
Not always.
independently wealthy. That's not what I mean. Independent, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
Yes.
with no allegations of
Yes.
no allegations of emotional abuse in years,
Yeah.
it's your opinion that not good enough. They're still on this power and
Well,
control.
all I can speak from my critical learning and studying this, and also my practice. And I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
Not always to your comment.
Nothing further, Your Honor.
Can this witness be released?
Yes, sir.
Yes.
Sir, you are released from
Are,
the meeting. You're free to go.
Thank you for all your help.
Read it. Sorry, babe. I misread it. My apologies. Man, I love cottage cheese, but this batch, ooh, that was the look you saw me give. It was like, that didn't taste good. Okay.
Mr. Taylor, call your next witness.
Gina Torsia, Your Honor.
Who?
I think we're gonna have to approach.
I don't see this person on the list. I need to hear that name again. I forgot to do the cross. I forgot to do the cross. It's okay. Oh, Lordy, y'all. They have some good moments together, so he must not have been abusive. No, I don't think that's what that to me is that you can be abusive and still have good moments together. You're correct on that. I didn't know that I was in a verbally abusive relationship until many years after separating. And I fought like hell to keep that relationship because I was so in love. And then now that I've been out for many years and I've matured and grown because I was in my 20s, I can see the manipulation. I can see all the red flags of the abuse. In one way that he would manipulate with me was threaten to leave. Of course, no, baby, I love you. I'll do it. You know, that's what I did. And I had no idea that that was being abusive. So, yeah, but we look like the perfect happy couple in public. Ah, you're all good. I think what she's trying to say is they lived apart for years. She lived with her mother. Very little communication. How in the heck could there be abuse at that time? What, baby? Well, come here. Come here. Come here. My little cat's sitting here crying. She missed us. I know, right? I want to know who the new guy is. I want to know who the new guy is. And she got together with him before this incident happened? I'm confused. When did she actually start dating the new guy? Before she shot or after? How all that come about? I could have sworn, but I've slept twice since then. More than that. She said on the stand that she was asked if she was dating the guy before she got the divorce. Mm. Sorry, guys. Hold on. Sorry about that. That was my child calling. Y'all know how that is, right? Your child calling. Oh, I forgot. I gotta go turn the lights on. I'll be right back.
Defense calls Gina Torsha.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
I do.
Actually, as she's sitting down, attorneys come back one more time.
I have found me something to eat. Rice cakes.
Hello, ma'am.
Please let me
Morning,
know
Diane.
about
How are
this.
Go ahead and have a seat. My name is Judge White. I'm presiding over this case. Just make yourself comfortable in that chair. You want to be about 12 to 15 inches from that microphone. You can adjust it up, down, left, right, however you need. And if you just speak in a loud, clear voice, we should hear you just fine.
Yes, Your Honor.
Yeah, that's good.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gina Torcia, Torchia.
Ms.
What was
Torcia,
her name?
did you
Gia.
at one time
Gia.
work for an attorney by the name of Stephanie Murphy?
Yes, sir.
Back in June of 2018, would you have been employed under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torcia, what I've marked as defendant's exhibit number 25
What does she do?
and ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay.
I'm
And
so
is
sorry
it
on my
an
mind.
accurate copy of your
Well,
email to him and Detective Gillum's response?
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Overruled.
All right. now,
Defendant Exhibit 25 will be received.
Ms. Torcia, did you on this day send Detective Gillum a copy of the South Carolina Domestic Violence Restraining Order?
No, because we were not aware of one.
Okay. Does he send you a copy of the order?
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us, Ms. Torcia, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Ma'am, can you slow down just a little bit?
Oh, I'm so
Thank
sorry. I'm a fast reader.
Okay. well,
sorry
just
about
slow
that.
down a little bit for us.
Evelyn Wood School. Huh?
Where do you want me?
You're good.
Okay,
6 months of the date of the hearing.
which was May, November, which was May, November 3rd.
Ms.
N-
Torcia,
Yes,
I'm sorry. Would you start over, please?
yes, sir. Gina, I noticed something that you both need to be aware of, unless there's something I am missing. If you read that section just before the judge's signature, it states the order will be placed for 6 months of the day of the hearing, which was May, November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, it's not something I would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay, we can agree that SAO would be state attorney.
Yes, sir.
So lastly, Ms. Torcia, this is Detective Gillum telling you that the order was in effect, the stay away order,
Objection.
as of November 3rd, 2017, correct?
Objection.
Sustained.
she
This
wants
is
to answer my
Detective Gillum
order. Well,
explaining to you.
Objection asked and answered. She read the email.
Sustained.
Just a moment, Your Honor.
You know, it's bad when you finally find something you can eat that's on your diet and you just want to eat the whole bag.
Ms. Torsia, let me pass you what I've marked as defendants exhibit 26.
Can I see it, please? Can we approach this?
I got to do this. I keep forgetting. Y'all. July has been an amazing month. And to end the month, we're doing a subscription campaign. And if you want to win a free Starbucks tumbler, just click the subscribe button. That's it. It's easy. Then leave in the comments, I sub, so we can get you in the drawing. The winner will be announced July 31st. Good luck, everyone, and thank you for subscribing. Well, guys, it's that time. We need a logo, we need merch, and a website. So I decided to have a competition. The person who creates the winning logo will get a t-shirt, hat, and a $50 gift card. And the logo will be featured on everything that we have. Facebook. Sorry. The lawyers came back.
So let me pass this to you. I want to see if this refreshes your recollection as to whether or not you sent a copy of the South Carolina order to Detective Gillen.
Yes, sir.
Well, I need to make an announcement. I told y'all that I was going to be gone tomorrow. That canceled. So I will be here for the entire live.
Yes, this is the order.
Yeah, without referring to it, my question is only, did you in fact, now that your recollection has been refreshed, send a copy of the order to Detective Gillen?
Yes, sir.
And then he responds to you a couple hours later with the email. that
With-
was introduced.
Yes, and there's also
No
an
further questions. Thank you.
Ooh,
Any cross?
snap it off. I need a snippy.
Finish your answer, please.
yes. There's also a predicament where Detective Gillum, there was no order entered in to the clerk system in Charleston, and there was no order entered into the Charleston Sheriff's Office. So he had no bounds to make an arrest just based on this when it wasn't entered.
Sustained.
Ask the
further questions.
disregard, Your Honor.
Members of the jury, testimony regarding an opinion's witness about violation of criminal law is inappropriate, and you should disregard those last comments.
No
Anything
further
else?
questions. Thank you.
Do you remember when she was talking about body bumping
Redirect.
the defendant?
Can the witness be released?
I found it.
Thank
Here's
you.
your body bump.
You're releasing your subpoena.
Would you like to? Thank you.
I found a body bump emoji.
Mr. Taylor.
I found the body bump. I don't think that went the way he wanted it to. He cut her off. I don't think that went very well. What do y'all think? That didn't sound very good for him. I found the body bump. She says body check. I accidentally bump into somebody and someone screams body check. I'm like, that's not what body check means to me. Oh, that's cute. Oh, here's my day right there. I found monkey. I'm having fun with emojis now, y'all. I know I shouldn't be, but I am. We got the boring part of court right now. Y'all know I have a monkey. I have a capuchin. Nala. I think the kitty likes her little pad I made her. She kept laying with the dog, and the dog was like, "I want my space. Give me my space. My space." So I threw a towel down on the floor, and she claimed it. I'm like, "Oh, thank God." The dog is learning not to wiggle its tail too much when she's around her, getting attacked. Yeah. Although I have to tell you, that hair is really dense on that dog's tail. She doesn't get scratched very often. What are we doing? I might as well go back and do what I was doing. Well, guys, it's that time. We need a logo, we need merch, and a website. So I decided to have a competition. The person who creates the winning logo will get a t-shirt, hat, and a $50 gift card. And the logo will be featured on everything that we have: Facebook, YouTube, Twitter, Twitch,
I think we're gonna have
the
to.
Okay,
website,
well,
my email, all the merch. So if you're interested, deadline's August
in
15th.
about
The
10
winner
minutes or
will
so,
be announced
feel free to
on
use the
the
facilities.
1st
You
of
can use
September. Thank you so much and good luck.
your phones if you need to send or receive text messages, emails, phone calls, anything like that. Please don't begin any sort of deliberations or discussions amongst yourselves about the case. Don't discuss the case with anybody outside the jury. And don't do any research on the people, places, things, or legal topics we've heard anything about. And 10 minutes, 15 minutes, because I also want to give everybody else a break as well. So, see you back in a few minutes.
And I have a customer. I'll be right back. Miss Diane, hold down the phone.
Y'all can have a seat. All right, so the issue is a police report that I haven't seen, but it's my understanding what it says is that Miss Benefield went physically to the telephone reporting unit of the Manatee County Sheriff's Office. I'm going to summarize, you can correct me. With
You had it right so far, though.
all right, so this isn't marked. Is it, did you seek to admit it as an exhibit or just testimony?
No, just testimony.
All right, so you expect the testimony would be from a deputy with the sheriff's office that Miss Benefield went to the telephone reporting unit on December 6, 2019. That Miss Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past. That she has observed him driving behind her on multiple occasions, which concerns her. and she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed. All right, any objection?
The objection, Judge, is that anything contained in this report, which the nature of this report, according to it, is information. But anything contained in this report is hearsay, other than that Ms. Benefield physically appeared at TRU on December 6th, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if you remember.
Proponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense. I do not plan to ask the deputy to read it. I'm going to ask him if he took a report from Ms. Benefield, what the date was, and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
And that's hearsay, in the state's opinion, Judge, because it's self-serving hearsay. It's actually hearsay within hearsay, I think. That if he wrote something and asking him what he wrote in a report about somebody else told him, but it's at least one level.
All right, thank you both very much. The purported reason for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed. That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle. And my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
So that's already in. And I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because put it this way, the tracker wasn't found, so it was just an information report. It doesn't matter if it was found or not. It doesn't matter if this officer believed her or not. The issue is, it's something she's aware of. She testified to an overt act. It's already in evidence. So at this point, this is not marked. Who's the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay.
Scott Lindsay.
It's on the
Scott-
top of the report.
Scott Lindsay, I'm sorry. Lindsey.
So, I mean, you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling it for, so. Yeah.
All right, I do want to give you all a break, though. I know we started at 9. It's about 10:30. I think it's reasonable to go ahead and take a break. So why don't you guys take 10 minutes?
Before we recess 10 minutes.
Okay, we are taking a break. I'm sorry, I had to run to the door. We had, I think, was a lead shooter incident here in Kerrville last night. I drove by, saw a ton of police vehicles, and I heard that there was a lead shooting event. Oh, I don't know. I'm waiting to find out. I want to find out what had happened. So I've been researching that all morning. So it's been an interesting day. Nope, they haven't posted anything. But they are doing their speed trap thing where they're telling everybody they're stopping Operation Slow Down. This is not how you want to start your day. So please be alert to the speeds. Oh, gee, cats, guys. All right, guys, let me put some music on. I'll be right back. I apologize. Am running it until he can get here. It's a Monday morning, and he is doing the bills and all of that. So I got to watch the shop. Oh, Cheap Views, thank you for hopping on. Javi, the person, okay, I can't read that. So, anyway, we were talking about naming the business. And one of the things is I wanted to have AKB Media. That's my initials. But then there is already that. And then I wanted maybe AB. Well, there's already that. So it's kind of like I can't find anything that I can do with my initials. So then I go AK Media, LLC. Well, then there's that. So they're all in different states. So I don't know what to do. I thought AKB ASL, because we are AKB Media ASL. What do y'all think? Maybe. How about that? That I could possibly do. I think I like the way that looks better than the first way, which was, oops, that's that one. And then this one was going to be AKB ASL. So, oh, I spelled it wrong. Ugh, I'm tired, y'all. AKB ASL MEDA. There we go. So what do y'all think? Which one? I'll let y'all put your input in. We are on a quick break. There's some things, I guess this is our morning break already. We hit 2,000 subscribers. Woohoo! We are doing so good. Y'all are so awesome. I appreciate you so very, very much. Oh no, MA versus Ricky, Boston firefighter fatally stabbed trial. We have not been following that. I kind of just put that on hold. So let me go check our view count, our sub count for the day. We're at 2021. Woohoo! Y'all are awesome. Y'all are rocking it, man. Y'all are rocking it. And let me see. I guess I can do a poll. I'm going to see. I guess I know where she is. I know where she is. Oh, he's not there yet. Oh, I guess she's not live with him, maybe.
All right, Mr. Taylor, do you have your next witness?
Defense calls Vincent Vizzacaro.
You ready?
Yes.
Okay. Yeah, let's go ahead and bring him in.
He's not on the list. Why do you give a list and not go by it?
Please make sure you have him spell that for the court reporter.
Yeah, that's going to be an interesting name.
Do you need the?
I did not see your answer, Tracy. Do it again. Do the answer again, beloved.
We'll wait till turn the lights down until you give us the high sign and the clerk will turn them down. All right.
Tracy, give me your opinion. I'll consider other names. I'll consider it. AdaKay.
All right, y'all can have a seat. Welcome back, everybody. Hope you got to stretch a little bit. Maybe run and jog in place, warm up a little. So we've got the defense going to call their next witness, but before we do that, I did want to ask that anybody begin deliberations amongst yourself, speak with anybody outside the jury about the case, or do any research on those topics we've talked about. He says no. Mr. Taylor, call your next witness, please.
Thank you. Vincent Vizzacaro.
That was somebody. Somebody recommended this, but I don't know if I want to go there.
As the deputy said, just make yourself comfortable in that chair. My name is Judge White. I'm going to be presiding over the case. You can adjust that microphone up, down, left, right as you need. Stay about 12 to 15 inches away. So we get a loud, clear voice. It'll pick up everything.
Sounds good.
Good morning.
Morning.
I'm back.
Would you tell
I'm
us
back.
your full name and spell your
I'm
last
back.
name for us, please?
Vincent Vizzacaro, Vizzccaro.
All right, Mr. Vizzacaro, I'd like you to try to keep your voice up if you could.
Will do.
I'm
What do you
here,
do for a
Ada.
living, sir?
I'm in real estate.
And
All right.
where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Did I get this right?
Do you have any particular specialty?
ACCARO?
Residential homes in Lakewood Ranch.
How long you been doing that?
About 8 years now.
I want to ask you whether or not back in 2018, you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a
Objection,
home.
hearsay.
I'll overrule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Liquid Ranch.
All right. And back in 2018, Mr. Vizzacaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Vizzacaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach them?
Yes.
Really? Already? Oh, so the last witness, I like that. Ada ASL Media. What do you think about that?
Are you going to bring me up or keep me down?
I'm brought you up for a reason. I want you to look at this.
Okay.
I'm trying to think of a company name.
Oh, yeah. That makes sense.
Or well, if I do Ada, what I could do is capitalize it and it looks like ADA.
Yeah, it does.
Would that work?
Sure.
I'm trying to figure. Want to make sure that whatever I do has media, because sometimes if I'm a media company, then we can get into courts as media.
Media. You can also go to the state fair and get much better parking.
I get better parking anyway. Show the badge.
Okay.
I'm kidding. I don't do that.
But with media, you can.
So ADA, ASL Media. What do y'all think about that? With it capitalized or not capitalized?
Capitalized.
But that is my name. ADA is my name. I think everybody likes the lowercase.
Well,
Oh my gosh, Andrielle.
what'd she say?
Brown Thumb Media.
Brown thumb or round thumb?
BROWN. My last.
All right, members of the jury, I do need a few minutes to resolve a legal issue. That's my responsibility. So if you could close your notes, leave them there on your chair, and I'm going to excuse you back into the jury room for a couple of minutes. I will get you back out here as soon as I can. Don't begin deliberations. Don't talk to anybody outside the jury, and no research on any of the issues. Thank you. All right, you all can have a seat. Mr. Vizzacaro, What I'm gonna do is at this moment, I need to do some research and speak with the attorneys. So I'm gonna excuse you to the hallway. There's a thing called the rule of sequestration that has been requested by both parties. And that means that you cannot discuss your testimony or the questions asked of you with anyone else. You can't discuss other witnesses' testimony or what questions they were asked.
Okay, poll posted.
While you report, or do any research
Oh,
on the
what,
case,
babe?
watch it, or anything else.
Understood.
All right, we'll call you back as soon as we can.
Okay, thank you.
Thank you.
Are you posting? Let me go look on my Facebook page. Go to that. Where are you posting, babe? Oh, it is? Okay, save
All
that.
right, I'm just gonna ask before I start doing my research, do
I'm
you have any cases you want me to know about right now?
posting in,
No, Your Honor,
All right,
you're not
so
posting
let's,
in
I'm sorry, go ahead.
we're traveling.
YouTube, you're posting
Words in
in,
statute, specifically 90.
Messenger.
803, 6.
Understood. All right, so I'm thinking I need about 10 minutes or so. So we're gonna take a 10-minute recess, maybe 15-minute recess. I wanna look this up as well, because I wanna find a case that gives me some direction.
Sure.
Yes, sir. Thank you.
See, I'm seeing you in instant messenger. I'm not seeing you in, you're not posting in the actual
Of course,
YouTube.
that means you can too, when we go back on the record.
Yes.
That's strange. Hmm. Weird. You're not blocked because you're coming through.
Who are you talking to?
Tracy.
Okay. Just figured you was talking to yourself.
Oh, why are they clearing the courtroom?
Because the judge has to look up and do some research on something to get some clarification on which way to go on something. He's looking for a case. That's why.
Matt, when you get a chance, I have a question for you. Come here. Which do you like of these for my business name?
The same.
No, look at the lower. ADA looks like America's
No,
Disability.
your
Act.
name. Your name.
Name? Okay. So that's what it's going to be?
Did you feed Ellie?
Oh, there was more than enough food. Sarah, one of you
Exactly.
dumped it.
Yeah, exactly.
Oh, no, there's food there. Go check. Someone may have eaten it.
Who's Ellie?
So we're on break because the judge has to do some research. Let's look and see. I want to kind of go back. I want to go back here and play. Okay, so he's stuck on evidence. Wow. Should I have the space between the L and the M? Miss Diane, take a peek. The way I have it just above Miss K. Swan.
I don't see it. I still don't see it.
I'm redoing it. Which one?
I don't see it.
It's in the comments.
Oh. No, it's not in the comments.
It's in the
Not there.
comments on YouTube or in Discord. But
I'm
no
not in this.
Messenger.
How do I find Discord? I've never been in
Not
it.
Discord, excuse me. StreamYard.
StreamYard. Well, I'm in StreamYard and it's not there. Not in the private
Doesn't do
chat.
space or caps.
It's not in the private chat.
No, it's in the regular chat.
Regular chat.
Up under
Chat with
comment.
Okay, well, I'm looking. Settings, present, leave studio.
Comments of the private chat.
Huh? Okay, I'm looking. StreamYard. No, that ain't working. Log in or create an account to send this stream to your own social.
Just go to the YouTube channel.
Go to the YouTube channel. All right, let's get rid of that. Let's go to.
Tracy, what do you mean it doesn't do space or caps? Are you talking about for the domain? Then it would be ADA ASL Media.
I'm going to YouTube. YOUTUBE. Okay, I'm in YouTube. All right, so what am I looking for in YouTube?
Go to the live channel. Go to the video we're on.
So you got to tell me what tell me what to type in.
No. Just go up under my channel.
AdaKay?
Yeah.
AdaKay.
Okay, I'll go to Messenger.
AdaKay. AdaKay. That's AdamKay. ADA, not Adam.
I saw it, Tracy, in Messenger. Love it, but I can't do anything till the 3rd.
All right, I'm not AdaKay. I get AdamKay. Is it just AdaKay?
I'm going to send you the link.
Yeah, that would probably be good because I'm not finding it, love.
Girl.
Buy me some coffee. Where did you send it to me at?
I haven't. I have to go grab it. Now I'm getting ready to send it to you in Messenger, babe.
All right.
Because I know you get things in Messenger.
Yes, I do.
Now click on that link and look in comments.
Just a minute. There it is.
Yep, Erica, I think that's what we're going to go with. Ada ASL Media.
Okay. Ada ASL Media. With the big one or the little one?
I think we're going to do with my name.
AdaKay? Or just Ada ASL Media?
Ada ASL Media. I don't think I want to do.
Are you going to do? Okay, you're just going to do. You're going to do Ada?
Yeah, let me look. Tracy's sending me information I need to look at. Correct, Tracy.
How do I save
my
this
gosh.
channel? All right.
Yes,
so
Tracy, to your last question.
Save.
No dash. Should we? Well, for the domain, we can't put a dash, but we can add a dash in like the websites and my headings and all that. But for the domain, you can't have any dashes. So, just should I have a dash or should I not? Trying to figure that out because we got to get a web page. We got to get all that stuff going. Should we put the dash between Ada and ASL? What do you think?
Hold on. You're asking me if you should put a dash between ASL?
I'm asking all of you.
All of you. I would say yes, but I don't.
Okay.
Don't do my opinion, honey.
Oh, keep it all the same. It's easier. Well, that little thing we can figure. But ADA ASL Ministries, no dashes. Miss Andrielle, we need to start talking about the web page. But one thing I've got to be careful with the web page is I also want to make it visually impaired friendly. I want it to be ADA friendly.
When you do that, don't you have to have somebody saying somebody's wearing a blue shirt and there's a candle over to the right and describing all that stuff? You don't want to say somebody's wearing pants.
Well, I do know that there's a way you can set it up. I'm trying to stay away from that. I'm trying to see no dash. Finally wanted to. There is a way that there is an accessibility button that they can click, and it will switch to all that.
Oh, well, that's great.
Gosh, I want my neck to quit being so. Got a kink in my neck. It's making it uncomfortable popping.
I don't pop like that.
Oh, man. But I do want to make them accessible. That's very important to me.
Oh, I can.
And then, guys, we got to get ready for our first members only live. I don't know what to do.
How much does members cost? I don't even know.
I think it's the ones who can. The membership start at $199, but access to members only live is $4.99 a month.
Hey,
But that gives you the emojis and all that kind of good stuff.
is that $4.99 or $499?
$4.99.
Oh, okay. I can breathe.
Yeah, we need to figure that out. I know, but I don't know what to do yet.
I have never had it take this long.
What?
My son put some money in my account because I was so overdrawn because I haven't worked in so long. And it isn't there yet. And I'm going, I am desperate.
It'll be there. Trust it. I'm a good girl. I'm a good girl. My little girl comes up and nudges me like, Mommy, I need some loving.
Is that Sensei?
Yeah. I go play.
Oh, I'm going to the bathroom, and next thing I know, I got a cat pulling my hair. Jumps up on the back of the toilet and goes.
Okay. I need ideas for the members only live. And the drawing for the subscriber will be tomorrow for the Tumblr. So that happens tomorrow. So, but I really apologize for not doing the Saturday tea. I was feeling so bad. I can't even, I thought I was getting COVID, but I'm fine now. But oh my gosh, case one. No, that was going to be a part of it. I wanted everybody to meet the mods, and the
This
mods
is Margie's,
time
not
we
mine.
can figure that out. I was going to have a Q&A. People can ask me about anything they want to know about me within reason. Talk about some of the cases and be able to use, because this is going to be non-monetized. So is a private. I got to figure out how to set it up. Yeah, but I got to figure out how to set it up. I don't know how to set it up. I'll learn by tomorrow. So tomorrow night is going to be the mods only member live. I mean, the mods only, the member live tomorrow night. That's the last day. No, I'm sorry, Wednesday night. Whew. Okay, I got 2 days to figure it out. Okay. Someone said play truth or dare. No, we're not playing truth or dare. Woohoo. Oh, that's okay, K Swan. Maybe you'll get a gifted membership. Maybe you can, if you're on, turn on gifted memberships. And if you're on when they gift a membership, you might get one. Somebody's been real generous with that lately. Unfortunately, that somebody is at work. Fortunately, that person is at work.
They like being at work, and I can't say that I blame them. As much as I
Oh my
enjoy
God,
doing.
when we started this trial, okay, there was only 4 of us ish. Who is Gina? Wants her day in court. Oh gosh. There was only 4 of us actually in on this. Now we have like 20 people covering this.
I'm
Okay,
the,
Miss Warren, we are praying for you.
well, everyone can pray for me.
We're praying for you too.
Thank you. We're back.
Any other objections?
Judge, also, I would like to make a relevance argument that the fact that he's going back and forth in this email about a specific property, there's no relevance to it.
All right, proponent, go ahead, sir.
Well, I think it's admissible, one as a business record, which we've already qualified. Business records traditionally contain hearsay. And under the statute, Your Honor, specifically subsection C, we got this email from
Diana,
the
your light
state.
looks perfect.
However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection according to the business records exception. We also believe that it shows Doug Benefield's state of mind that he was in the process of buying a home directly behind Ashley Benefield's home during the time period when the South Carolina injunction was in full force and effect.
All right, anything else, sir?
No, sir.
State?
Judge, I found a case I would like to Thomas v. State 993 Southern 2nd 105 from 2008. It is specifically addressing an email that was put in as a business record. I didn't have long to read this, but It was an email that was sent to an apartment complex manager of some sort. And it appears as though it was not qualifying as a business record. And additionally, the hearsay within the email was not admissible. There is a yellow flag and I'm trying to look at it now.
All right. Did you review Thomas v. State, Mr. Taylor?
Yes, sir.
All right. Do you want to make any argument on it?
No, sir.
So Thomas v. State is helpful. So 993 Southern 2nd 105 First BCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the
Hey guys, forgive me. Let me go back a second. I want to explain just what happened. I now have a domain. Sorry, guys. Someone was helping me get that set up, and I had to hop off. Sometimes when people are helping you, you just do. And now we got our domain. Now I want to hear what's going on.
So Thomas v. State is helpful. So 993 Southern 2nd 105 First DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record, and I don't see where they actually found and held that the email was a business record, which was my original question, but ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that although hearsay may exist within exhibits that fall within an exception, such as business records, those hearsay statements must still qualify under a separate exception to the hearsay rule. And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzacaro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Van Sant v. State, VANZANT, 372 Southern 2nd 502, Florida 1st DCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. But the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is his state of mind. It clearly shows Mr. Benefield. Let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence. And here is Mr. Benefield, Judge White, negotiating with a realtor to buy the house directly behind the home where Ashley Benefield lives. And he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern and practice. That corroborates
Oh.
your defense.
Do you want to be heard on 90.8033, an existing mental, emotional, or physical condition?
Judge, his emotional, mental state, that still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house, and he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
Wow, this is getting interesting. The matrix.
All right, as I've said before, are you going to establish the location of the home through Visicaro,
Yes, sir.
where it was
Yes, sir.
in relation to the house where Miss Benefield lived?
Yes, sir.
And then are you going to then just argue during closing? I would assume.
Yes.
All right, so there's going to be no more witnesses. This is the end of this road to establish
Yes. This is just
witness-wise.
This is an isolated act of DV. Yes.
All right.
Judge, if she didn't actually know about this, then I don't know that it's relevant.
Well, and that's what I was thinking, because, hold on, it's not an act of violence, though.
Right.
Or threat. But under 9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, design, when it's offered to prove the declarant's state of mind, emotion, or physical sensation at the time or any other time, or prove or explain acts of subsequent conduct of the declarant.
And Judge, I would just ask that this witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email. Just, were you helping Doug Benefield and were you looking at a certain house?
I think that would obviate some of the evidentiary concerns I have, that you asked if he was assisting him in finding a location. Did you find one? Where was that location at that you were talking about putting an offer on?
Indeed, and if the court rules against the admissibility of the email, that would be my intention. On behalf of Ms. Benefield, though, I would like to present the best defense that I can. And I think that the email clearly is something the jurors can have, read, see. It's tangible. It has the same kind of impact, Judge, that the prior inconsistent statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be kept out, I would like to admit it.
All right. Thank you both very much. I'll allow the admission of Defendant's Exhibit 27 under 90.803(6) for the realtor's portion and 98.03(3) for the Benefield portion. With the understanding that, again, this is a relatively collateral matter.
In and out, Judge.
All right, can you call, can you bring the witness back in, Mr. Vizzacaro? All right, welcome back, sir. Just take your spot back there in that chair. We're going to get the jury back in and resume your testimony.
Sounds good. Thank you.
Bring them in. All right, y'all can have a seat. Welcome back, everybody. You're ready to begin deliberations. Talk with anybody outside the jury about the case or do any research. Everybody says no. Mr. Taylor, you may resume your direct examination.
Thank you, Judge White. Mr. Vizzacaro, when we last broke, you told us you were a realtor and that Douglas Benefield had contacted you relative to a house in Lakewood Ranch.
That's correct.
All right, I'm going to pass to you, Mr. Vizzacaro, what I've had marked as defendant's exhibit number 27. That would be the email messages that you referred to before when we were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's exhibit 27 will be received.
Now, Mr. Vizzacaro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you. And as luck would have it, we have the pointer. Okay, so this will give you
the beam. Okay.
Would you please show us on that diagram where the house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now, that house, is it directly behind the house in front of it with a red dot on it?
Yes. Yes, it is.
Okay. Do you know, Mr. Vizzacaro, who was living in the house with the red dot at 11331 White Rock Terrace?
No, I don't.
And do you know whether or not, if I may, You know whether or not, you don't know who was living in this house?
No.
This is the house that Mr. Benefield was interested in purchasing.
Correct.
Do you know whether or not Mr. John Sant lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything further. Mr. Vaccaro, my oversight. I'm going to pass to you what I've marked as defendant's exhibit number 28. And ask you if you can identify it.
I know, right? Poor Jules.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport News Circle.
On
Excuse me.
behalf of Ms. Benefield, Your Honor, move to introduce that as defendant exhibit 28.
No objection.
Received.
That's all. Thank you very much, Mr. Vaccaro.
You can
Gotcha.
cross.
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just
That's right.
grab it real quick. And for the record, this is case exhibit 27. And it appears as though you're speaking with Mr. Benefield about potentially this house coming up or the price being lowered on this house, correct?
That's correct. Yes.
All right. So you were contacting Mr. Benefield about
I reached out to him about that.
Okay. And he actually said he may just want to rent. Isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashley first.
That was a comment that was later in the conversation. Yes.
Okay. And if I could show you State's Exhibit 27, it's very small type at the top. So you might be able to.
That's why.
For the record, defense exhibit.
I'm sorry, Defense Exhibit 27. Does he say there that he needs to speak with Ashley first?
It appears that way. Yes.
Okay.
Yeah.
Thank you. No further questions.
Can you redirect?
Nope.
Can the witness be released?
Yes, sir.
Ma'am?
Yes.
All right, sir, you're released from your subpoena. You're free to go.
Thank you.
Mr. Taylor, can you state defense? Can you approach real quick?
All right, call your next witness.
Defense would call, Your Honor, Dr. Jason Quintel.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
Yes.
welcome back.
Hi there, thank you.
As you may recall, my name is Judge White. I'm presiding over the case. Same rules as last time. Just make yourself comfortable. Adjust that microphone as you need. Speak in a loud, clear voice.
Good afternoon, Dr. Kinsey.
Hi there,
Welcome back.
thank you.
As a result of the counseling sessions that you had with Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. Opinion testimony.
You go ahead and approach.
I think I need a
Nobody
nap.
can hear me. Oh my gosh, I'm so sorry. I don't know how that button got turned off. I didn't touch it. Did you fall asleep?
Yeah,
Don't do that. You're live.
I know.
No, there's
Yes.
a button I never use to mute the mic. It's in the program. I always mute it from my soundboard. And how that button got pushed, I don't know.
It
I
just
told you.
happened.
Heck,
It just
heck.
it just pushed itself.
Oh, it's a Monday. It is a Monday. What can I
Tell me
say?
about it. Tell me about it.
Well, I am. It's a Monday.
It's a Monday.
Oh.
I do not know what is going on.
Well, they just keep going up to sidebar, and it's really starting to irk me. It's driving me crazy because um
You not crazy. You AdaKay.
is that 8 or 1? I gotta figure that out. No, it's driving me batty. Just
You not
batty,
batty. You AdaKay.
batty. I'm batty.
Well, I'm just trying to find out why this isn't doing what it's supposed to be doing.
CB1. Okay, that is correct. Oh, I am sending my color codes for my website. So they're international color codes. So it's universal. So it's great. I can just send her the codes and they'll have the exact colors so they match with my Canva. I got to shut the door. I can hear my son. I wish y'all could see my puppers. My puppers is laying down and she's snuggled up with her bunny. She's all with her bunny.
She got a bunny.
I mean, even she's sleeping through the day. She's got a little bunny. When she came to us, she did not have any toys. She wasn't into toys. And now she is. We've taught her some things. She wasn't a toy dog, but now she'll get excited and grab her toys and wiggle her butt and look all cute. Oh, guys. Poor Jewel, she's blowing on her hands. She's so cold.
Jules. Yeah.
So we are up to 199 objections. So one more, and we're at 200. Poor Miss Jewel. She's just sitting there trying to stay warm. Hey, Haley Mouse. I know Diane was laying her head back, and I thought I didn't know it was muted because I looked over at the sound, and I was like, why can't she hear me? The button in the program was muted. How? I don't know how that happened.
And we never know how things like that happen.
Well, I was typing, so I may have accidentally yep. Wow, this is happening fast, y'all. Really fast. I didn't think I'd even be thinking about a web page for another 2 months. Oh my gosh. I'm overwhelmed. I really am. Right now I'm
Oh,
sitting here.
don't be
thinking
overwhelmed.
we
Don't be
started
overwhelmed.
with just shy, I think, of 400. And last week of June, we went from 80 to 400 in 2 days. The last 2 days
Wow.
in June.
I'd
So
like to sit
we're
and get.
looking,
Hey, Joe.
if we're looking at the numbers starting as of today of last month, I think we're about 100 and something members, if that much. And so we have grown almost 2,000 in a month. I would love for us to grow in the next 2 days by at 100 subscribers in the next 2 days, because that would make it exactly. So I'm going to say 1,850 in a month of subscribers. And yeah, insane website.
Okay, Dr. Quintel, so a couple of questions about your practice.
Yes, sir.
I think you told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms, and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
I don't do specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
All right. Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection. Qualifications.
Sustained.
Did you counsel Douglas Benefield?
I did, yes. Both
In-
Ashley and Doug.
All right, and in counseling Douglas Benefield,
A
did
sweet
you
justice.
listen and absorb the various points that he was making to you?
Yes, both when they came in as a couple, and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay. And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Okay. Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection. Foundation.
Would you approach, please?
Okay, guys. What I'm going to do, guys, in member chat, for those who are working on a potential logo for me, I am going to put in there my colors. There, they've been posted. And I will put in there the color codes. You need them because I would like for you to use. And the color codes are in the same order as the photo colors. So that will help you. So the color codes and in the members chat, the color codes are in the same order. I know we have people wanting to help with the logo. So thank you so much. I appreciate it. We are now at 201 objections.
A brief deviation, Dr. Quintel. Tell us what degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been
Clinical
practicing
psychology?
as a psychologist?
I got my master's in 98 and started working in the public school system. So since 98, 2006, I started a private practice.
And since you've been in private practice, Dr. Quintel, can you give us an idea of the number of patients that you've seen in counsel?
Thousands.
And your specialty in counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
Okay. And when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally, the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory, so emotionally the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment. right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment. So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
So that's basically.
And in that process, do you typically employ listening to patients?
Yes.
Do you typically employ making suggestions to patients?
No.
I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome.
Okay. Now,
So more instead of a suggestion, it's more of kind of a mutual outcome.
all right, and you went through this process with both Doug and Ashley Benefield.
I did, yes.
Your Honor, I would tender Dr. Quintel as an expert in the field of psychology.
Do you want to voir dire the witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
All right.
You do most of your work now in trauma resolution, correct?
I do, yes.
Okay. And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
I don't look at diagnoses with people. I look at people because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or, bipolar? I would say I work with people, not the disorder.
So when you're dealing with, for instance, Doug and Ashley Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to get at is there's a difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay.
Get on the mic.
So your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma, and there was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Thank you for the question.
You may resume your question.
So in treating people, not the disorder, you still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Quintel as an expert.
And I
You
would
wanna hear
reject.
any- Same objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you. So, Dr. Quintel, all right, we're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male?
Losing.
I would say that
Objection.
Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
Did you conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintel, about whether Doug's depiction of himself as being godly was reliable?
You can't question somebody's spirituality.
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes,
I think it was over the top.
Oh,
Right, and did
wait.
you
Whoa,
reach
whoa,
any
whoa, whoa,
conclusion
whoa,
as to
whoa,
whether
whoa, whoa,
genuine-
whoa. Over the top spiritually? Is that what he's saying? Religiously? Hold on, let me get you on. Say that?
He wanted to know, did he reach any conclusion to Doug's opinion of his godliness?
Godliness. That
I don't,
that
I don't, I don't think he's talking about spirituality.
well, godliness, whatever. He has no right to even judge that. What one person's level of connection with God is not the same as with somebody else.
I think he's going back to the conversations on the cruise when Doug
Ah,
was saying, get rid of them, I'm God, that kind of thing. That's what
okay.
he's
I
talking
didn't hear
about.
that. That may have been on our potty break. Okay. Whew. Okay.
I did not think it
Stand
was fully
corrected.
genuine, no.
Did there come a time when you inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child. And I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
What's up with all the leading
I
questions?
know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection, if I may.
Y'all, Mhm. Hi, Miss Jules. You watching Eva?
Thank you.
Does that refresh your recollection, Dr. Quintel, as to Doug's perception of letting Ashley get away from him?
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintel. Did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as
Objection, hearsay.
Sustained.
did you reach any conclusions, Dr. Quintel, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
Objection, relevant.
Overrule as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child. And I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed with Emerson, the child, outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all, Your Honor.
Cross.
So you mentioned that it bothered you, or at least you noticed when he didn't go out to see the child. How long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child.
Yes, I did.
Okay. And I believe, and correct me if I'm wrong, in your direct examination, you said you met with Ashley Benefield alone 5 times.
Yes, ma'am.
And you met with Doug Benefield alone twice.
Yes, ma'am.
And you met with them together twice.
Yes, ma'am.
So the majority of the time you met with Ashley Benefield, over half of the times you met with her.
To do trauma resolution. Yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
Okay. So it was not solely based on things that you were observing in Doug Benefield.
No, ma'am.
Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State.
Yes.
All right, sir, you're releasing your subpoena. Thank you very much. Here you go.
Thank you.
Woohoo! Yoo-hoo! I'm out of here.
Can we publish the couple of exhibits that we put in through this music column? And then a whole bunch of breaks for lunch. I don't think that's.
Oh, that's not, yeah. Oh, you have 27?
one photograph was already in,
One.
and then one we added together with these.
Yes, so members of the jury, we're gonna pass these out and publish them. I'm not rushing you, but I'm gonna talk while we're doing that. I think at this point, it's a good time for our lunch break. It's about 10 minutes after 12. So take your time. I want you to look through all of this, look through these exhibits, and then I'll excuse you.
26 and 27.
27 and 28, and they'll be marked on them. There's a little sticker on each. Which should say 27, 28, and I think the other one is Defense Exhibit 1.
Sneaky side. I don't know what I'm going to have for lunch. I got to go do something. I didn't get breakfast. I got my cottage cheese, and it just tasted. Oh, so don't know. Isn't no offense to men in general. Most men are alpha. Isn't that about right? Am I? Where's my man? I need my men around here. We don't have enough testosterone. No, need some testosterone. Oh, what are you making, Miss Kevin? What is you gonna have for lunch? What I really want is a slot piece. Flatbread. That's what I want. I'm not gonna get it. And guys, we need to start planning our very first members only live. So if y'all want to be a part of that, you need to be a judge level or higher. That's $4.99 a month. And I think what I'm going to do while they're doing this, I'm going to mutt them. That paper is driving me crazy. And Miss Kevin, can you see the live now? Yeah, I did the same thing this morning. I did the same thing. Oh, I know better. It's 9 there. You're in Cali. You're Cali. You're in California, aren't you? Or at least that coast. Mhm. So, Miss Kevin, you didn't get to see this, but I'm going to show it to anyway. Did I? There it is. Go to the live. I want you to see this. Hey, y'all. I want to give a huge shout out to my favorite mod. Nah, just kidding. All my mods are my favorite, but she's my right-hand mod, and I call her my mod boss. Her name is Miss Kevin, and I just want to say, girl, I couldn't have done this without you. Love you, and I look forward to many, 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 many more posts and lives with you. Be blessed, and thank you for all you do. Yep, did that for you. You're welcome, beloved. Now you know why I wanted that character. Andrell, I don't know. I just got the domain name. Don't know how to do that. Don't know how to say that. I'm struggling, y'all. I don't know. Misa Nonosa. Misa Nonosa. I loved that character in the movie. Oh my God, what was it? Misa. Underwater. Star Wars. Star Wars. Misa. I loved me Misa. I loved Misa. So that will be good. Reply. Sure. Send. And this Saturday. Oh, my mama is speaking at a globe. Oh, we got so much going on this weekend, y'all. Oh, I need to go in my. I got so much going on. Finally, did it come through? I love it when something sends you a code and then you can't find it. Driving me crazy. Didn't get it. I'll have to do this later. Okay, we are back to sound.
We have,
Without asking what they're going to ask.
There we go. Jar Jar Binks. Yes, I love that. I love Jar Jar Binks. Yes. Misa, Osa. Misa, sorry. Misa. I say Misa a lot. Andrea, I will ask my friends about the email and how do I access all that.
All right.
We'll
So
figure
it's
it out.
4:15. If I could have you back down in the jury assembly room where you began everything this morning and last week at 1:30. Should give you plenty of time if you want to go somewhere, if you just want to walk downtown. Be in the jury assembly room at 1:30, and we'll get you back up here as soon as we can to get started for the afternoon. Remember the admonishments, don't talk amongst yourselves with anyone outside of the jury, or do any research on the people, places, things, the legal topics we've heard anything about. Thank you.
Okay. So y'all, what we're gonna do is I'm just gonna leave the stream up. I'll have music going.
All right, y'all can have a seat. I would assume, before I let you all go, that the request for an exhibit list from the defense of the items that they expect to introduce has been provided,
Yes.
right? And certainly a list of witnesses that are expected to be called.
Yes.
Right. I didn't get a copy of that. If it's been amended from the witness list that I received, it looks like it was filed June 21st of 2024. So I'll just mark, but who do we have on tap for this afternoon?
so.
I don't need to know the order, but just who?
We have, Jason Alexander, Michael Haag, Haag, Dr.
Hold on
Emma
one
Lou,
second. I'm sorry. I got, my list is, okay. Michael Haig,
Michael Haig, Dr. Emma Lou,
all right.
and Warren Justin.
Warren,
Justin, the lead homicide detective.
all right. When we, none of these, have all these folks been deposed?
Yes.
All right. Are there any objections or anything I need to hear before, before we get a jury in and get them seated and make them sit there for 5 or 10 minutes while I hear arguments at the bench? I would much, much rather have the objection made. Let's talk about it, and then let's call the jury in so it's a little bit smoother.
With
Amen.
Detective Warren, I may have objections, but I don't know what's going to be asked. So without
Oh, no.
asking what they're going to ask, I don't think we can have that conversation. And additionally, if Detective Gillum is set to testify, I would have similar objections.
You didn't say that name.
No,
You should have called.
Okay. You think just 1, 2, 3, 4 witnesses are going to take us the whole afternoon?
Yes, I think there's a reasonably good chance we rest today.
Okay. Oh, is this the bulk of what you're calling at this point?
Yes, sir.
Okay. Well, that would be fine, because then we could do a preliminary charge instruction this evening. Then you guys can decide if you want to do any rebuttal. Okay.
So the one request I do have, Your Honor, is for Mike Haig, who's our ballistics expert.
Mike,
We need it.
Mike
Mike Haig.
Haig, yes.
J-A-G.
Okay.
We need the HDMI cable to run to the witness stand so he can plug his laptop in.
To where? Here? I don't understand.
Yes. Projected. Yeah, so it'll be up on the projector.
So he's going to use his laptop to project here.
His testimony, yes, sir.
I know this is the one we used. I don't know, Deputy, does that stretch to here?
We'll inquire and we'll check it out.
Oh, you know what? IT has got to come and fix my computer anyway. So can you tell them that we also need that a witness this afternoon is going to have to run to that?
So
Thank you so
sorry.
much. And then that'll take care of both, because my goblins, it's just, you know how it goes.
Okay,
All right.
Lunch break.
thank you,
Aye.
John.
I guess the only other question the state would have is there were other witnesses that were held by the defense. If these are the remainder of their witnesses, are those witnesses being released? Because they're asking the state. for this.
We don't know what they're presenting.
Yeah.
in rebuttal.
Okay.
Oh, wow. Did you hear that? Okay, guys. This is what I need to do. I need to go get lunch. I need to then come back and work with Andrea on the webpage and get some answers for her. So I'm just going to leave this screen up, and it says we'll be right back. Court is in recess, and we will be back on in an hour. Thank you guys for joining. I appreciate you, and we will see you in a minute. In a hot minute. I'm back. I hope y'all are still with me. Thank you guys so much for being here. For those of you who watch RA, y'all need to go throw him some love. They've had a little family thing happen. He and his wife are okay, but RA, no, we love you. Get my pillow straight. We love you. We're praying for you and your family. Oh, forgot my baby. Say, I'm so sorry, baby. Mama's such a bad mama. Mama's such a bad mama. I know, you're good. You're such a good girl. I gotta clean off my desk. Here you go, baby. She goes, Mama, I deserve a treat for that. Yep, she does. That's water. So I got for lunch California flatbread. Oh my gosh, I love the California flatbreads. They are so good. But no napkins. Luckily, I have some right here. So, well, I listened to some other YouTubers and wanted to know what they thought about the religious thing. And I think everybody is of the same census because he sent spiritual text every morning. He was over the top spiritually, religiously, whatever. That really angers me that he can make that assumption. I don't think that was a fair thing to say in any way, shape, or form. Should say, go lay down. Please. My favorite part of this is the very end. Very end of it. For me, you cannot sit there and say to me that because I send my friend, spouse, kid, whatever, a text every morning with the scripture encouraging them that I'm overly religious. You can say he's controlling, you can say a lot of things, but that overly religious thing kind of got me. Hey, Matt, can you get that? I'm covered in ranch. I just dripped ranch down my shirt. Go figure. But anyway, just want to let you know I'm here. I'm going to finish eating. We'll be right back. Did you take that stuff home? How are you, Miss Diane? Hey, gotta unmute you so I can talk to you. What you doing, love?
Hello.
Your work?
I was looking for a specific email giving me the name of a doctor so Margie can make an appointment.
Yes, Miss Kevin, my heart's breaking for R.A. and his family now, too. He announced it on his show. His
What?
sister had a miscarriage. I think it was it a miscarriage? He said lost baby. So was it a miscarriage or was it a already born baby?
Doesn't matter. Either of them are tough.
Either way is bad. I was just
Yeah.
yeah. He got the text as soon as he was just getting ready to get off from the live, so he kind of hit right then and there. Miss Kevin, are you going to be in background today on StreamYard? I miss seeing you. Miss Andrielle, hello. We have a domain. I tried to go into Google and create an email do a professional page, but they said they had to send me a code. Well, I never got the code. And because of that, I'm locked out. It just ticks me off.
I know all about being ticked off. Ugh. But I really work hard at it not to get ticked off. Ooh.
So, I need to find a host for the email. And then I need to find, you should know how to do all that, right, Andrielle? And as soon as Doug transfers the name over into the domain over to my account, then we're good to go. I let him know we have a GoDaddy.
You have a GoDaddy.
I just signed
GoDaddy webpage.
GoDaddy account. I hate the name GoDaddy. It just
Yeah,
that
I understand.
doesn't fit well with me. Yeah, let me give him a call.
I'm not going to be able to be.
Huh?
I'm not going to be able to be on here until they finish today. I've got some calls I have to make.
Go for it. Understand? If you
gotta.
do, if not, it's okay.
What'd you say?
If you can hop back on, do. If not, it's okay.
Okay.
I'm pulling money out of my boat. I'm sorry, Miss Diane. Life happens.
Oh, you're telling me nothing I don't know.
All right. I'll talk to you in a little bit.
All right.
Prayers and blessings and peace.
Yes, ma'am. And like I tell everybody, get home safe. Nowadays, that's my tag.
Bye, love. Okay, guys. All right. He is getting ready to kicking her out of studio. I hate that kick out of studio. I hate that. Okay. What's wrong, baby girl? What's wrong? What are you playing? What you playing? I love you. So, oh my gosh, I'm kind of overwhelmed by this. I think so. If not, I could probably figure it out. Well, as soon as he's working on getting everything transferred to my GoDaddy account. As soon as he does that, then you just got to link it. I got to create an email. Oh, such is life. Everybody's having a hard Monday, y'all. I really feel for everybody who's struggling today. Just remember, today's almost over. Today is almost over. And you'll never have to come back to this day again if you're having a bad day. But is Court live already? Oh, Court's coming back. He gets it a few seconds before we do. I'm gonna.
All right, looks like my real-time viewer is working again. All right, welcome back, everybody. It's after lunch now. We're all back in 2020 CF 30.
Hold on, I'm listening to RA. Oh no, that's so horrible, guys. Hold on. Oh my gosh. Okay, I'll share with you. RA's saying that they knew the baby would not live very long. And it
014.
way into
Is there anything we need to talk about before the defense calls its next witness?
and
All right.
I've
As soon
been
as the jury comes up, let me know and we'll bring them on in.
so what ended up happening was the baby passed in utero. I don't know how far they were in utero, but the baby has passed on in utero. And so my heart and prayers go out to the entire family.
Paper.
It affects all of
And
them.
everybody's pen is still doing okay?
So, all right,
Just let us know if
as a
not.
woman
I
who's
hope you had a good lunch.
one of them
Did anybody discuss the case amongst yourselves?
and your
Talk
family.
about the case with anybody outside of this group, or do any research on people, places, things, or legal topics, or get any information about the case? Nobody says no. All right, Mr. Taylor, call your next witness.
Thank you, Judge White. Defense calls Justin Warren.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole
We're
truth,
calling Justin Warren. Justin Warren is detective.
Thank you. Just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. Just up, down, left, right, however you need. Loud, clear voice, and we'll hear everything.
Yes, sir.
Your Honor, with the court's permission, permission to treat as a first.
You can go ahead and approach.
How many times I just look at this judge? He's like, God Almighty, didn't we discuss this?
The ones with the most knowledge of the case. Would you agree?
We do collect everything at the end, but we do have meetings, so everybody's pretty much aware of what's going on.
All right. Does the lead detective develop the theory of the case?
We work as a group, so like I said, it's pretty much a group effort.
It was an hour. I held back just for a minute because I wanted to update because a lot of RA people are over here as well. So we send our sympathies and heartfelt condolences
Do you
to
recall being asked the
including
following
Germans.
question on May 16, 2023 at a deposition? Question, okay, so part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
The answer is still sure. Yes, sir.
You want your investigation, especially for homicide case, do you not, Detective Warren, to be objective and fair?
Yes, sir.
With conclusions supported by evidence.
Absolutely. Yes, sir.
Yeah. Not speculation.
That's correct.
It's not something, given the nature of what a homicide investigation entails, that you want to jump to conclusions.
That's correct.
Did you submit an arrest affidavit for Ms.
Objection.
Benefield?
Pretrial rule.
Just asking the question.
Overruled at this point.
Did you submit an arrest affidavit for Ms. Benefield?
Yes, sir.
Did you represent that?
Objection, pretrial rule.
Sustained.
Did you describe?
Objection, pretrial rule.
Go ahead and ask your question.
Let me ask you this. Was it your position that based on the entry wounds to Douglas Benefield, that it did not appear he was facing Ashley Benefield when he was shot?
Based on what I knew, yes.
And as it related to the chest wound, what did you base that on?
Well, whenever we have a homicide investigation, one of our detectives will go to the medical examiner's office for the examination and obtain a preliminary finding. We don't actually receive the medical examiner's report for several months to maybe even a year in some cases.
You're aware that the medical examiner's finding here was that he was shot from the front.
Sustained.
As it related to the wound to the leg, Detective Warren, what was the basis for your conclusion?
I'm sorry.
As it related to the wound to Douglas Benefield's leg, what was the basis for your conclusion?
It appeared that he was shot from the right side of his body.
Can we agree that you got both of those wrong?
I wouldn't say so, but I'm not a doctor. I would ask the doctor.
Okay, so it's your position as you sit here today that Mr. Benefield was not shot from the front?
That's not the way that it appeared when we did our preliminary investigation with the medical examiner, and then later on.
And it's your
Preliminary. Oh, sorry. So preliminary is the key word. Preliminary is your key word. I got to shut the door. It's gotten real loud and noisy in here. I apologize, so I had to go shut the door. Yes, it is heartbreaking. I lost twins at 20-ish weeks. That was the longest I carried a baby that I miscarried. But most of them were between, I had a few like at 12, but most of them were between, 12 and 17 weeks. And then 22 weeks was the longest. And it's horrible. My last attempt at a baby was my daughter that was born successfully. So I have a son and a daughter. My son was pregnancy number 9. My daughter was pregnancy number 14. So, yeah, heartbreaking. So, heaven forbid, Puppers wants in. My gosh. Are you telling me? Okay. Yes, ma'am. Yes, Missy. Yes, Miss Royalty here. Are you demanding entrance, my dear? Is that what's happening? Was that what that was? So you demanding to come in? You get, oh, no. So you want a treat? There you go. I'm sorry, y'all. Miss Kevin. That is true. When I had my first couple miscarriages, I told a few friends, but I didn't tell a lot of people.
If we're going to need a couple extra minutes to handle this one. If I could ask you to step out, close up your notes, step back in the jury room. We'll get you back in as soon as we can. Remember, don't begin deliberations, talk with anybody about the case, or do any research on the people, places, things.
He is pissed. He is pissed. I got past miscarriage number 4. I didn't tell anybody because people started saying I was making it up. You can get pregnant. Sometimes you just.
We really need to address some legal matters about your testimony. So I'm going to ask you to step out into the hallway. The rule of sequestration has been invoked, so you're not to discuss the questions asked of you or your testimony with anyone. You have to talk with other witnesses about their testimony, the questions asked of them. You're not supposed to do any research about the case or watch anything.
Yes, sir.
Y'all, this judge, I hope he rips them new ones. Because this is ridiculous. Almost every freaking witness, we have to kick out the jury.
All right, the witness is out. So there's, as I understand it, there's going to be several areas of cross-examination regarding Detective Warren. And the state has objected on the longstanding doctrine that you can't call a witness solely to impeach that witness. So that's where we're at. And the line of question where we stopped was going to involve statements made by the detective in his probable cause affidavit or arrest affidavit. All right, so these issues were addressed, and I seem to recall that I allowed these at the stand your ground hearing, and this may have been the footnote where I said rulings at trial may be different. And there's also been a pre-trial motion regarding impeachment of Detective Warren and what is relevant and material and admissible. And I said, I believe my ruling was that it would have to be shown
at the time of the cross or the direct and the attempted impeachment to show that those criteria are met. So, State, what else did you want to put on the record?
Judge, only that this keeps happening, and we did hours of litigation about these issues, so we would not have this problem in the middle of trial.
Preach
Now,
it.
almost every sentence that comes out of Mr. Taylor's mouth, I have to object because he is not following your rules or the rules of evidence. So I would ask that we try to get this ironed out now so we don't have to call the witness back and I have to object 5 more times. He has clearly only called this witness for impeachment purposes. That is the #1 first objection that I have.
Sure.
All right, I called this witness to establish substantive evidence. I asked him, what does being the lead detective on a case mean? Is that the one who has the most knowledge of the case? Do you develop a theory of the case? He resisted that. I impeached him with a prior acknowledgement. He then also said and confirmed that he would want his investigation to be objective, fair, with conclusions supported by evidence, not speculation, and that it's not something that you would jump to conclusions on. Now, that is my substantive evidence predicate. And based on that alone, if nothing else, I am now allowed to argue to the jury, don't you think it's strange that the lead detective on a homicide case would not be called as a witness on behalf of the state? So that's my substantive position. Along the way, I should be also likewise entitled to impeach him. For example, he has testified that you would not want to jump to conclusions on a murder case. You'd want it to be objective, fair, conclusions supported by evidence, not speculation. All right, fine. Is it not true that within an hour and a half of this shooting, you referred to this as murder? I then want to ask him, do you believe all homicides are murders? If he says yes, good. If he says no, then I plan to impeach him because he made that statement in his deposition. I then want to ask him, and do you believe that all people who kill are murderers? If he says yes, fine. If he denies it, then I plan to impeach him because he made that statement in his deposition. I don't see why that is not a fair game, respectfully. The only other question I had of him was he had authored a supplemental report on November 16th of 20. And in that supplemental report, there is a provision on the report for bias, referring to the subject, Ashley Benefield, and he checked the box, or either checked the box or wrote in no bias. I plan to ask him about that.
And what report is that?
That is a report that he authored, a supplemental on November 16th of 2020. And referring to Ashley Benefield as it relates to the victim, Douglas Benefield, he wrote or checked the box that says no bias.
What are the other options?
Well, the other options are hate, spite, ill will.
No, on that form.
No, the form it's an open form. It's for him to put it in there. Here, I'll show the court the form.
What'd y'all have for lunch? I had a Schlotsky flatbread. What bread?
It says bias motivation. He types in none, no bias. The next block says bias target. It's blank. And the box after that says bias circumstances. That too is left blank. Like me to show you.
First, I don't think he filled that out.
No, I will tell the court in deposition, Detective Warren questioned whether or not he had filled that form out, despite the fact that it's got his name typed on it. That's going to be a question of fact for the jurors. It goes to its credibility, not its admissibility, respectfully.
All right, the line, thank you. The line of questioning that you seem to be starting with was the line of questioning that the stand your ground hearing where a narrative was established. And then I believe it was shared with the state, and then there were some amendments, and then it was shared with the state, and then there were some amendments, I think, to final form.
All I proposed to ask him here was, did you write a witness, hit Ms. Benefield with a box? And I want to ask him if he knew who that witness was. And he's going to tell me it was Doug Benefield. Then I'm going to ask him why he didn't say that. Give us a reason why you would not have disclosed that rather than put a witness.
Judge, I feel like we litigated all of this. And this was supposed to be shown to the court outside of the presence of the jury so you could make a predetermination before the jury came out. I would like to know the relevance of what is in his arrest affidavit. He cannot call a witness to the stand and say, do you do a thorough and fair investigation just so he can impeach him with this stuff that he's trying to get in. He calls him and says these questions and calls them substantive evidence. It's not substantive evidence. It is setting him up so he can get in all of these items that he thinks are impeachment. We have gone over this before, that what is in this arrest affidavit is irrelevant. What the judge signed the arrest affidavit. You said in your pretrial order that the use of the word murder versus homicide, my motion was granted unless this defendant can establish to the court why this is relevant. And the defense did not say anything different than what they said before when we argued this. Also, any edits of a warrant or search warrant or anything in the warrant, same thing. So I really don't understand why we're back here arguing this again. The arguments are exactly the same. He calls this witness, asks a few questions to set up impeachment. It is disingenuous to say that this witness is called for anything substantive other than attacking his credibility. He was never a witness. Why is he attacking the credibility of a witness that never testified?
So as I understood the court's ruling, until such time as I could demonstrate the relevance of it, it was not admissible. I think the relevance of the lead detective believing that all homicides are murders is overwhelmingly relevant.
Please explain. I understand, and you said that multiple times in multiple hearings.
Yeah.
Relevant to prove what?
Bias. This guy executes a search warrant within 45 minutes of the shooting, referring to it not as a homicide, but as a murder. We've already had testimony from at least two deputies, and in particular, I'll remind the court of Lieutenant, I believe it was Dickens, who? Dickerman, who testified that not all homicides are murders, that the reason you have to take time to investigate a homicide is to determine whether or not there's been criminality. So here's the lead detective who initiates the theory of the case. Within 45 minutes, he's calling it a murder rather than a homicide. And he makes the statement that all homicides are murders and anybody who kills is a murderer. And the court is going to instruct the jurors, if you feel her action was justified, then she's not guilty, because not all homicides are crimes. How could that not be relevant?
This witness never testified.
Any further thoughts?
No.
All right. Yeah, these, we've already covered this ground. So it was,
Sanctions.
it answered a question just a moment ago about what was the purpose for calling this witness. And the law is very clear. And I think both sides know this area of the law. You cannot call a witness solely to impeach that witness. Asking if that person is the lead detective, is it important to be fair and objective? Is it important to rely on facts? Is it important not to engage in speculation or jump to conclusions? Those are not substantive questions regarding the investigation. Those are just general questions to someone about being objective and fair. In this particular situation, and I'm skipping over the part about any argument about the state not calling the lead detective in a case. I'll leave that to whenever it's presented. I think we all know the law on that as well. But the answer I got is, what is the relevance of him referring to, in a search warrant within an hour and a half, a murder? What's the relevance of his opinion? This is an opinion. Are all homicides murders? That's an opinion. It doesn't matter what he thinks. If he thinks that all homicides are murders, or all murders are homicides, or there's some mix of the two of them, that's a jury question that the jury is going to have to answer. I can't think of any witness I would let speculate or testify as to whether this case is a homicide or a justifiable homicide or an excusable homicide. That's the province of the jury.
Judge Kemp, may I ask?
I tried to give both sides as much time as they wanted to put information on the record. The question, are all people who kill murderers? Again, what I'm asking is, what's the relevance of that to show his bias? There hasn't been anything established that he was particularly biased in any way, or how that would be relevant to this particular case when it's an opinion whether people are kill or murderers. That's going to be a jury question to decide whether the state has proven beyond a reasonable doubt its allegations of murder in the second degree with a firearm, or if the facts and evidence support a lesser included offense, or if the state has not met its burden and the defendant is not guilty, whether they haven't met their burden or because the jury believes and finds that the defendant has acted in lawful self-defense. The other issue about the statements made in the probable cause affidavit, it's my understanding that's going to be asked is, did you know who that witness is? And again, I'm struggling to understand how that is relevant into any particular issues in this case.
How about this, Your Honor? Does the court think if, as the lead homicide detective, Justin Warren would have said, I'm not going to seek a search warrant because I think Ashley Benefield was abused and I think her actions were justified? That would be his opinion. But if that was his opinion, she might not be sitting there right now. That's why I think it's relevant. He initiated the prosecution. And you were hearing from somebody who initiated the prosecution who is overwhelmingly biased. He acted impetuously. He acted without evidence. He got both of the entry wounds wrong. He completely speculated that Mr. Benefield was not facing her when she was shot. Their own medical examiner said he was facing her.
State anything else?
No, Judge.
Mr. Taylor, I am certainly giving you as much room as I can to cross and impeach on relevant and material issues. But from what I've heard so far, and I will just say that the impeachment from earlier regarding theory of the case, that was not materially different. But so far, the questions you have asked and the questions that I've heard you represent to me and issues that you intend to represent and question this witness on are all impeachment issues.
All right, I have two questions remaining. Will the court allow me to ask them? One question is, I want to ask him if he spoke with the medical examiner before he submitted the arrest warrant. And the last question is, did you fill out this supplemental report and indicate no bias? That's it. Then the only thing left is I want to show him the DNA report and have them read the section that's applicable. We gave them business.
Isn't that just a cutie?
Well, hold on.
Okay.
The two questions that have been stated at this point, the two questions, just to try and get objections out of the way and get them ruled on so we can get this going, is one, two is this supplemental report, nothing regarding bias. And the first thing again?
And the first one was, did you speak with the medical examiner before you submitted the arrest warrant? I think he's already testified to that.
I think he did.
None of it is relevant, Judge.
All right.
And I will be asking for a curative instruction depending on the court's ruling.
All right. And then you wanted to show him
The DNA.
DNA report.
Yeah, he submitted the exemplars and he got the report back.
All right. I don't know if I've seen that.
Friend, go back and watch.
You may not have. We'll be happy to show it to you if you like.
But what is the relevance of showing a detective a DNA?
Hold on. Yeah. Plus, it's a report. It's not been authenticated.
We gave them the notice of the business record. They did not file an objection to it. And it shows that the court may recall crime scene swab, both of Miss Benefield's hands and wrists and forearms. And the DNA came back as Douglas Benefield was one of 3 potential contributors out of 740 million or whatever the figure is. And the court may recall Miss Benefield testified on the stand that she attempted to flee the house. Mr. Benefield ran after her, grabbed her, spun her around, and blocked the door so she couldn't get out.
Yeah, but it's okay. Go ahead.
My objections are not to the business record certification, Judge. My objection is the contents of the report there has not been a foundation laid to make that report relevant. There has not been a witness that testified that swabs were taken and then turned over. There's not a witness that said, I'm speaking. There's not a witness who says that those swabs were taken from Ashley Benefield and then those swabs were sent to DNA labs. So anything contained in that report that says there's DNA from Doug Benefield or Ashley Benefield is hearsay. There's not a person at DNA labs that can say where those swabs came from. They only know is they got them from the sheriff's office and somebody told them where they came from. And I think that the probative value is outweighed by the prejudice because it's going to confuse the jury. It's a packet with bench notes and the report. And the report, there's no witness here to testify to explain a very complicated report. This isn't even ballistics is somewhat simple. This is DNA. It's extremely complicated. And I think that the danger is that it will confuse the jury and that the proper foundation has not been laid. So my objections are not to the business records, which is why we did not file an objection. It is to the contents being hearsay. There's an insufficient foundation to enter this, and that there's a unfair prejudice.
I'm quite comfortable relying on the court's notes, and if the court checks its notes under Megan Dorvac, the court will see that Megan Dorvac testified after being called by the state that she swabbed at the sheriff's office that evening Ashley Benefield's hands, arms, and forearms for DNA evidence. And I even specifically asked her if the purpose of that was to be able to determine who may have touched her on that occasion. She agreed. Now, Warren submitted those DNA samples to the lab. The lab returned those DNA samples to Warren.
It's driving me.
Now I'm going to ask him what the result was. And I have the DNA report for the court if it would like to see it along with the business certification records of the custodian.
I've seen plenty of them. All right, anything else?
No, Judge, that's not how any of this works. There's been no swabs. There was no witness that said, these are the swabs I took from Ashley Benefield. There's been no witness that said, these are the same swabs that were sent to DNA labs. There's been no witness that said, those are the swabs I received. There's been no establishment that anything in that report is related to this case based on anything other than hearsay. Which, I'm sorry, I already said all those things, but it's just frustrating because they're all the steps to get that reported under certified business records have been skipped. And so, although I don't object to that portion of it, it's the contents being hearsay and improper.
As a proponent, I'll give you the final word, and I need to make a ruling.
Well, just say the state never filed any objection. They've been noticed plenty of times.
Yeah, this is a really easy call. That lab report is not admissible. You could call the DNA analyst who could come in under 9702 and establish the foundation and the bases to admit DNA evidence. After the chain of custody has been established, there's been no evidence. I haven't heard anything at all about I heard about swabs. I don't recall seeing the swabs. I heard about swabbing being done, but then the chain of custody, getting them to whatever lab did the testing to ensure the integrity of the evidence. Then at the lab, what are the testing processes, procedures, known error rates, all of the foundations you would need under 90.702 and 703, 704, 705 about how this all happens. And then, of course, we need the analyst to explain what these results are. So that lab report doesn't come in. In addition, it's prepared in anticipation of litigation. I mean, that's the whole reason it's done. So that one, that was an easy one. That is going to be prohibited, crossing Warren on the DNA report. The other two, though, the state objects. I think it's fair to ask Detective Warren if he spoke with the medical examiner before he sought an arrest warrant, and you can ask him. I think if that's his supplemental report, I think it's close, but I'll let you ask him. Here in this box regarding bias, nothing is there. But out of everything I've heard, those are the only two questions that I think are relevant and material and appropriate of everything we've talked about, and aren't solely to impeach. So, all right, let's.
And Judge, I would just ask to establish the without bias part without speaking it out loud to the jury first.
I don't understand what that means.
He's leading this witness and speaking what's on the report before the witness even says he wrote it or anything. So
right.
I would
So
prefer that he
establish if it's his report,
establish that down on, right here, there's a box that says a bias. What does that mean to you? And he left it blank. And is there anything in particular that why he did that? But that's the extent of what I've heard relevant. So let's bring it back in. All right, sir. Did you speak with anybody about your testimony, or did anybody approach you to speak with you? Did you talk with other witnesses about their testimony, or the questions asked of them?
No, sir.
Did any research on the case, watch it at all?
No,
All
sir.
right, let's go and bring the jury in.
Yay, we're done. We have our entitle, our domain. Woo-hoo-hoo-hoo-hoo. It's not what I want. Y'all, this is just insanely exhausting. Insanely exhausting.
All right, y'all can have a seat. Welcome back, everybody. Did you begin deliberating amongst yourselves? Talk with anybody outside the jury about the case? Do any research on people, places, things, or this topic? Everybody says no. You may resume your direct exam.
Thank you. Detective Warren, did you speak with the medical examiner yourself before you submitted your arrest warrant in this case?
Well, like I said earlier, we have a detective that will go to the scene or to the medical examiner's office to get the preliminary findings.
Let me repeat my question, Detective. Did you personally speak with the medical examiner before you submitted your arrest warrant in this case?
Not that I can recall.
All right, let me pass this to you and see if this refreshes your recollection.
Sure. Okay. Yes, sir. Yeah. So I spoke to him on October 29th in reference to stippling.
You documented in the report, did you not?
Yes, sir.
All right, my last question, Detective. Do you recall filling out a supplemental report on November 16th of 2020?
I filled out a lot of reports, sir. May I look at it just to verify?
Sure.
Okay.
Is that your report?
It appears to be. Yes, sir.
All right, can you tell us the date of the report?
November 16th at 15:10 hours.
November 16th of 2020?
Yes, sir.
All right. Let me ask you if there is a provision in this report for you to note whether or not any bias or motivation is demonstrated by the offender towards the victim.
It's a program that's got a lot of different stuff, so there could be possibly, sure.
All right, let me ask you this. Under bias and motivation,
Okay.
did you put in none?
Well, it would have just been not filled out. It auto-populates. Like I said, it's a program and I'm not a programmer, so I apologize.
So if you had been aware of bias on behalf of Ashley Benefield towards Doug Benefield, such as ill will, spite, evil intent, things of that nature, you would have noted it, would you not?
Honestly, it probably would have been just documented in the report.
No further questions.
Cross.
This section that says bias, isn't this for hate crimes?
Yes, ma'am. When we fill out certain areas for certain crimes, it's required for statistical reporting and things, and a lot of things that I'm not even aware of. I don't typically pay attention to that box, but
So this box is for those kind of statistics, not for any kind of bias that may be going on in this case.
correct.
Thank you.
Redirect.
Do you think it odd that you're the lead detective in this case and
Objection
you weren't called
beyond
by
the
the
scope.
state?
Sustained.
Ooh. Getting a little snippy here.
Can this witness be released?
Yes.
No.
He's like,
Remain under
yes,
subpoena, sir.
get out of
The
here.
Instructions I gave you about sequestration remain in force.
Do I need to stay in the building or can I leave?
No, sir, you can go, but you
Okay.
need to be available in case somebody calls you.
Yes, sir. They have my email. Thank you.
Call your next witness.
Try to come back to it. We call Dr. We call Michael Hay.
Oh. Did he say Michael Haig? Yeah, not really. A little snippy snip between the people, that's all.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thanks, sir. Appreciate it. My name is Judge White, presiding.
Oh, please.
Get about 12 to 15 inches from that microphone. You just up, down, left, right. There you go. I'm just speaking a loud, clear voice. It'll pick up everything.
Thanks, sir.
Good afternoon. Will you tell us your full name, spell your last name?
My name is Michael Haig, H-A-A-G.
What type of work do you do, Mr. Haig?
I'm involved in forensics. Specifically, a typical job title would be forensic scientist.
Let's talk about your educational background. Where'd you go to school?
My formal education is as a chemist. I have a bachelor's of science degree in chemistry from the University of Arizona in Tucson with a math physics minor.
When you speak of forensics, what are we referring to?
Forensics in the broad scope simply means the junction or the joining of science and the law. So it's where somebody who is particularly interested in or has been trained to examine physical evidence brings findings or an interpretation of that physical evidence into the courtroom.
Could you describe your forensic career history for us?
My background and training is fairly unique in that I grew up in this field. My dad, Luke Haig, also does this kind of work. So even in grade school, I'd go out and assist him with both casework and research, and I got the bug.
Yeah, I like
So after I went to college and got my degree,
I went and worked for a private consulting firm that he ran for about 2 years or so, followed by an application and employment with the Albuquerque Police Department Crime Laboratory, starting in about 1998. With APD, I worked for about 25 years and got to the retirement point and was able to retire. But during that same time frame, I also ran my own private company, specializing in my sort of primary area of interest in forensics, which is shooting incident reconstruction. The study of the physical evidence relating to shootings, the interpretation of that physical evidence, and the reporting on it, of course. With the Police Department Crime Laboratory, I wore quite a few hats. Primarily, I worked as a firearm and tool mark examiner, which someone in that role particularly focuses on the physical evidence relating to those things. But I also worked in drug chemistry as well as blood and breath alcohol, and was a supervisor of those units for about 12 years as well.
Any additional training and or classes that you have taken in order to be skilled at your job?
The list is fairly long. Honestly, I don't remember everything that I list on my CV. But as far as training and expertise, I've been trained and taking classes from everything from the FBI at Quantico to doing cross trainings with the San Diego Police Department, in-house training with the Albuquerque Police Department. I regularly attend conferences and seminars. I worked for the German Bundeskriminalamt. You can spell it. Bundeskriminalamt, which is like their FBI. So I interned with them for a while before I came to the Albuquerque Crime Laboratory, and a wide variety of other trainings I've received over the almost 30 years now.
Are you a member of any professional organizations having to do with your specialty?
I am. The ones that are particularly relevant to what I do would be the Association of Firearm and Tool Mark Examiners, or AFTE, the American Academy of Forensic Sciences. EMFC is one that I've been a member of for about 2 or 3 years. That's the European Network of Forensic Science Institutes. They actually have some very, very interesting perspectives on forensics, among others, including the Association for Crime Scene Reconstruction. But that's another bug I got from my dad, is being very active in the field, seeing how other units do things, as well as participating in those conferences.
Have you authored or published any scientific papers?
Quite a few. Another bug I got from my dad. I publish very regularly in scientifically reviewed, peer-reviewed journals, such as the Journal of Forensic Sciences, the Association of Firearm and Tool Mark Examiners Journal, amongst others.
Written any textbooks?
Luke, my dad, and I wrote a textbook, one of the few on shooting incident reconstruction. It's in its 3rd edition now. And I'm also the author of a chapter in the Encyclopedia of Forensic Sciences on shooting incident reconstruction.
And how about, Mr. Haig, any forensic presentations of note?
I very regularly present both at conferences as well as for organizations on this area of work.
Can you tell us what certifications are offered in the area of firearms identification and comparison work?
The primary certifications, which a certification applies to an individual, and accreditation applies to a laboratory. So those are terms you'll often hear mixed, but certifications available and that are relevant to what I do include 3 from the Association of Firearm and Tool Mark Examiners, 1 in gunshot residue and distance determination, 1 in firearm identification, that's the examination of microscopic tool marks, as well as tool mark identification, the examination of microscopic tool marks from other things besides guns, like screwdrivers, hammers, and things like that. And then when the International Association for Identification had a certification, they've discontinued it, for crime scene reconstruction as a whole, I applied for and took that. All these tests involve both the knowledge test as well as a practical examination. And the AFTE ones, which are still active, of course, require recurrent training and testing.
Have you been recognized and testified as an expert before in a court of law?
I have.
Approximately how many times?
At last count, I think I'm getting close to 100.
And where have you so testified?
Primarily in the area where I worked for most of my 30 years in New Mexico, in Albuquerque. But in addition to that, all across the country, to include states like California and Texas and Rhode Island. And I'm not sure if I've been to Florida before, but many, many states across the country, and courts ranging from district or regional courts, state courts, to federal courts and military court martials.
Mr. Haig, have you given your opinions in high-profile cases before?
I have.
Give us an example.
The cases that come to mind would be Aaron Hernandez in Boston. That was a high-profile homicide trial. I've been involved in the examination of physical evidence in places like Taiwan, even for presidential assassination attempts, or cases from Iraq, and many other places that I lose track of.
Are you an instructor in any areas of forensics?
I am.
You've written on the subject as well?
I have.
And you provide regular training in shooting reconstruction?
One of the areas that I actually gain a lot of pleasure from is instruction in shooting incident reconstruction. So this is the examination, as I said, an evaluation of any physical evidence when a shooting takes place. That can involve the crime scene itself. It could involve trajectories. It can involve a wide variety of things within that sort of umbrella title. But I've taught a shooting incident reconstruction course for almost the entire last 25, 26 years of my career. They're week-long live fire shooting courses. So this isn't just a thought process. I go out and shoot things so that people that do what I do, crime scene investigators, forensic scientists, even pathologists, can come and see how these shootings take place and understand what they're looking at when they go into a scene. So I do that very regularly, especially now that I'm retired. I'm able to do about 4 to 8 of those a year, it seems like.
Is the assessment of bullet trajectories taught in your SIR courses?
It is.
Can you describe for us what a 3D laser scanner is?
This is a tool that I actually feel very lucky to have helped brought into the crime scene realm. It's an engineering tool, technically. But if you think of a laser rangefinder, a very simple one that you might aim at something, push the button, it shoots out a bullet of light. Light travels at a very consistent speed. So when that light is reflected back to the sensor, time is measured, and we then can calculate a distance because of that time and the known speed of the light. That's one bullet of light. A 3D laser scanner is an engineering tool that sits on a tripod and has such a thing inside of it, but spins in a 360-degree azimuth, left and right, and also is able to shoot out the laser beam in a vertical path as well. So imagine in this room shooting out millions of bullets of light and collecting individual data points on a very accurate scale, and then blending all those individual data points together. You get a representation of reality. You get a computer takeaway of your scene, and then you move that system from one place to the next, so you can move around corners, and you can blend all of these data sets together so that you really take the crime scene with you. So I was lucky enough with my police department to help start this theft of this technology into crime scene back in about 2005. And since then, many departments have also seen the value of it, particularly with trajectories, in my opinion. And it's become a very common tool across the country and internationally as well for crime scene investigation and shooting reconstruction.
Mr. Hay, can you define for us what exactly a trajectory is?
When I'm describing a trajectory, I like to think of it or describe it or liken it to a snapshot in time. If you imagine yourself in a dark room, completely dark, and things are moving, and you set off a strobe from a camera, let's say 3 times in that dark room while things are moving around, then you've really frozen things in place for that brief instant while the strobe was going off, or in our case, when a shot is going off, because bullets move to our perception of reality in a very fast manner, of course. And so if a bullet, say, goes through something and then strikes something else, it can help us orient those objects that are struck, and indeed then where the firearm is as well. So snapshot in time is how I tend to think of it, but it's a way of understanding where things were, including potentially the firearm itself, as well as objects that are struck.
All right, so you come upon an investigation, if you will, of a shooting incident, and you reconstruct it, correct?
I try to.
All right, now would you tell us the significance, the importance of trajectory as it relates to that reconstruction?
In forensic science, you in very many ways have to throw out what you may have seen with regard to TV. Most of the things that TV puts out are completely false. But the beauty or interesting thing about trajectories with regard to shooting scenes is that fact that it gives us a way of assessing where things were in those moments of time. A person in my role may not be able to say exactly what happened in between them sometimes. Sometimes there's a logical progression of what might have happened given the physical evidence that we do have. But in my job, I basically lay the pieces of the puzzle on the table, meaning what physical evidence I have to look at from a shooting scene. And that could be the projectiles, the cartridge casings, the firearm itself, or trajectories, the room, and then try and see what snapshots in time we may have available to rebuild.
Is there a distinction between what you've been referring to as trajectory and wound path?
Wound path is sort of a subset of trajectory. Wound path refers to, indeed, just that, the path a bullet took or created when it goes through a body part in specific, or a body. But in each case, the accuracy and the meaning of those trajectories can be evaluated, because bullets, for the most part, there are exceptions, tend to travel in more or less straight paths. Like I said, there are absolutely exceptions to that, particularly with, we're not dealing with, in this case, non-expanding rifle bullets. But we look at these paths as relatively linear. Every measurement taken by human beings is an approximation, though. So an understanding of how much accuracy to place on those measurements and that documentation is absolutely, of course, important as well. With trajectories into things like walls, when I have good points to work with, or data from somebody's scan of a trajectory rod in place, for example, typically about plus or minus 5 degrees is what I've found from my work, and what I would call a industry standard in my work around a measured trajectory, around a straight line, if you will, that was created by something like a trajectory rod. With wound paths, it can be a little more difficult, and this is something I've lectured on to not only the pathologists in my area, who I worked closely and well with and helped train when they'd come in as fellows, and then I've lectured on at the Swiss Wound Ballistics Workshop 2 years ago, I think, and was asked to lecture on, is the idea that not only are trajectories in bodies a little bit more inaccurate because of the way they're measured and how bodies move, we're not walls, we're not rigid. So we have to indeed look at those as a little bit more of an approximation. But for the most part, with things like we're looking at here, expanding handgun bullets, that category, we can describe them or think of them as relatively straight lines as documented. They give us an idea of where a firearm may have been at the time a shot was fired based on that path. So wound ballistics is a subset of just trajectory. They're related.
You may have alluded to this. If you did, my apologies. What is the degree of accuracy of trajectory reconstruction?
With regard to common things that I typically deal with in crime scenes, like walls, sheet metal in cars, desks, almost anything you can think of, I shoot in my classes to demonstrate this and basically check ourselves and see how accurate we are, about plus or minus 5 degrees. So I'm motioning with my hands to make sort of an arc. So if my primary line of measurement, we're going right down the center of my wedge here, I'm making a visual representation of approximately plus and minus 5 degrees, a 10-degree cone overall if you rotate that into 3 dimensions. But I think I can show you that later.
What steps did you take in preparation for your testimony here today?
When I do a case review such as this, there are materials that I typically would like to see in order to help inform myself on what evidence, what pieces of that puzzle are on the table to include, particularly documents, things like crime scene images, autopsy images, autopsy reports, lab reports, all the documentation that goes around a typical investigation, as well as 3D laser scan data, if it's available, amongst other things.
And in this case, did you examine all the evidence that was available to you?
I actually forgot to mention that. In addition to that, in this case, I did examine the actual physical evidence, meaning the projectiles, cartridge casings, etc.
And when you say projectiles, we're referring to the bullets.
Correct.
All right. And this information that was provided to you by the county, correct? By the sheriff's office crime scene?
Which information were you talking about?
that you were able to review in preparation for your testimony here today?
I think technically I received it through you, with the exception of the 3D laser scan data, meaning the documentation, the crime scene of photographs and autopsy reports.
Do you recall whether or not you actually came to the sheriff's office to do a review of the evidence?
Absolutely.
All right, let me ask you with that preface to tell us, please, about the projectiles in this case.
The examination of the projectiles helped me understand in a way where they'd been. And this is sort of one of my main areas of interest, is the damage to projectiles sometimes, depending on their condition when they finally come to rest, can tell us something about where they've been, and what they've hit. Especially if we're dealing with particular types of projectiles, such as we're dealing with in this case, which are expanding handgun bullets. This basically means that we're dealing with a construction that is designed to change shape if that projectile strikes something that is liquidy, and we are mostly liquid, so that would include tissue. A hollow point projectile is typically designed such that it has an external jacket made of copper. So my hands here are representing copper, and then that goes around it in 360-degree rotation. So in this demonstration, my finger's pointing up. That's the way the bullet would travel. A hollow point projectile has just indeed that, a hollow point cavity in the nose of the bullet. And it is designed that way such that if it's traveling stably, nose forward, and that hollow point cavity encounters something liquid, could be a gallon of milk sitting on a countertop, doesn't matter, or tissue. The liquid actually goes into that hollow point cavity, and because the bullet is traveling forward, you build up hydraulic pressure, liquid pressure, just like the brake lines in your car, inside that hollow point cavity. And so pressure inside that hollow point pushes the sides of the bullet open, and it comes open like this. So if I take my hands and make the model bigger for you, the jacketing material, the copper jacketing material that's facing forward as the bullet travels, when it encounters something liquid and expands. Some people like the term mushroom. I don't prefer that term. But when it expands or encounters soft damage, the pressure builds up. And so that jacketing that was facing forward actually peels backwards, down and around. But it leaves you with a forward-facing area of the projectile that's greater than the original caliber. Mushrooms, so you get greater surface area presented to the way it's going. And when you do that, you increase drag. And when you increase drag, you decelerate or slow that bullet down more quickly. And so these bullets undergo, or created through intense engineering by people at the companies, such that they go a preferred depth in tissue or tissue simulant. So the main reason for hollow points in handgun in particular, whether that's somebody in law enforcement or somebody interested in protecting themselves, as opposed to going to, say, the range, would be to control penetration depth. So this bullet will stay in one body, and you don't over penetrate and go through further. When I work cases that have non-expanding bullets, often called full metal jackets, typically you can see over penetration. You can go clean through one person and on into another. So that's the hollow point cavity mechanism.
Where were the bullets in this case, Mr. Haig, recovered?
From my review, there were 4 fired cartridge casings and 4 projectile. Even though it's stuck in a wall, just barely, you can, in the crime scene images, see it stuck in the soft drywall, because it's downrange from the bedroom where all of the fired cartridge casings, biological matter on the floor is. But that hallway gives us sort of a path, a trough that the bullet had to have passed through. There were no other documented impact sites in that area. So we have what's called ballistic accessibility. It creates a path into the bedroom area. If we assume that's where the firearm was, which is a logical assumption, in my opinion, based on the cartridge casings, the biological material, that doesn't overlap with another trajectory. I'll come back to that in a second. Our 4th bullet is found on the floor in the bedroom, in the middle of the floor. Its position to me does not really mean much, because it's laying there just on the floor where it could have been kicked, could have been moved slightly. So we don't know where else it might have struck in that room. But the key thing about this bullet, and this is bullet number 5, as I recall, is that it does show soft damage. It is expanded. In the images, you would see the jacketing material is peeled directly back and is facing rearward. The damage to this bullet tells me it went through tissue, something soft and liquidy, not things like wood and drywall or glass, but rather tissue. In this case, is our limited universe option. So this bullet, number 5, would have had to have gone through the gunshot wound to the leg, which, as I recall, enters on the interior left portion of the leg and exits out to the right side of the leg itself. So those 4 bullets, and each one has a story to tell about what it did or did not strike.
When you speak of tissue, we're speaking about tissue of the human body.
I am.
Okay, just so we're clear. Now, did you bring with you today any slides or any type of diagrams that will assist you in your explanations?
I have 2 things that fit that bill. I have the Manatee County's 3D scan data with trajectories for one shot that I could show, as well as images I took of the 4 projectiles that I just mentioned that would help illustrate my points if you need me to.
All right. Before we get to that, let me just finish up the wound path. I'd like to ask you about the wound path to the shot in the chest. Are you able to say, based upon your training, experience, and education, whether or not that wound, where the shooter was relative to that wound?
Of course, I wasn't there for the autopsy, but experts rely on each other's reports in order to formulate opinions. The entrance is generally on the right, front side of the chest here. The bullets were covered in the back left area. Because bullets of this type, expanding handgun bullets, travel in relatively straight lines when they go into tissue. If you simply extrapolate those lines from the autopsy report, it gives you an idea of where the firearm was. I typically speak in terms of the firearm itself as opposed to a person. Of course, a firearm is just a machine, so it typically has an operator. So how that person is directly placed with the firearm is beyond my physical evidence examination ability. But the firearm, if you put a line straight back from where the bullet entered to where it went, it gives us our best approximation of where then a firearm would have been at the time that shot was fired. Again, that snapshot in time.
Are you able to reach any conclusion with respect to the order of the shots?
There's nothing in this from the physical evidence standpoint that allows me to sequence these shots 1 through 4. If one starts to make assumptions, which some people recoil at the word assumption, as long as you have a legitimate reason for saying the word assumption or are willing to
And as long as they're not disruptive,
describe its
they can
validity,
definitely crochet.
we make assumptions in science all the time. It allows us to make further steps. So, for example, we have 2 trajectories through the body. We have 2 trajectories into objects into the crime scene. If I look at the trajectories just within the crime scene, one that has to go through that long hallway, and one that we actually do have some data for to figure out where the firearm was that just goes into the wall within the bedroom. And we look at those 2 trajectories, they don't overlap, meaning there's not a physical possibility for the firearm to have been stationary between just those 2 shots. I can't tell you with regard to sequencing which one was first, but if you make an assumption that the firearm, if you're the firearm, I mentioned right to left, moved from right to left, then the one down the hallway would have to have been before the one into the wall, if that's the hypothesis. If we take the opposite hypothesis, it's opposite left to right. That's where witness statements come into play to evaluate whether or not the physical evidence supports or refutes a witness statement. You never take a witness statement, and in my line of work, believe it. You look into what the physical evidence supports and then cross-compare them. So if you have information or an opinion or a statement that the firearm was indeed in motion from right to left, the physical evidence for those 2 trajectories would support that. As far as the body, for me, this case doesn't help too much because I focus more on the scene in this case. Others have focused on the body. But with regard to the scene itself, with the body itself, certainly we have an idea of where the firearm was relative to that body. But because those bullets don't then continue on to hit other things within the scene, I don't particularly have an opinion there that would lead me to allow me to then say sequence those in order.
Do you have an opinion as to whether or not the deceased was stationary or moving?
If we assume that the firearm was relatively stationary, and by that I don't mean a matter of 3 or 4 feet, I mean the firearm is not circling about the room, going out in the hallway of this incident, or otherwise. If we take the position that the firearm is generally just in the bedroom and is pointed in the same relative direction as the 2 trajectories that I've described for you, then it would have to be that the decedent was in motion, because we have trajectories in the decedent's body that are almost opposing. We have one that goes from, as described in the autopsy report, and this is how it's commonly described in such things, front to back, right to left, and as I recall, relatively flat. I think it was maybe slightly downward, but I've forgotten the vertical component. But the key factor is that one goes this way. And as I read the autopsy report, the other gunshot wound enters the inside of the right leg and comes out the exterior outside of the right leg. These are basically 2 relatively opposing trajectories on an object that undeniably, in my work, objects, bodies regularly move in between shots for one reason or another. So given that, to me, those trajectories in the body indicate to me that the body was in motion.
All right, and with respect to the firearm itself, are you able to draw any conclusion whether or not that was in motion as well?
Certainly within the degree I've described before, with the 2 trajectories that I can show you, the one that goes in the wall, for those that I can demonstrate by physical evidence, there was some motion. And as I recall from my measurements in the 3D scan data, it's something like 4 or 5 feet, at least, from one position of one trajectory's area over into the area of the other. As an approximation, again, because again, trajectories are approximations. Otherwise, beyond that, no.
So would it be safe to say that your conclusions support the fact that both the deceased as well as Miss Benefield would have been moving from right to left?
I can't tell you that the firearm moved from right to left of those shots. A statement of such would be supported by those 2 trajectories that I mentioned.
All right, would you please demonstrate for us now from the slides that you brought how you reached the conclusions that you did?
Sure, it'll take me just a minute to set up the laptop.
Yes. Yes, please, Your Honor. Thank you.
Anybody good with? Oh, it's been a day. Anything else different color switch for each sustained and overruled objection? It'd be like a visual story on trial. Yeah, that would be funny. That would be funny. We're up to 215 objections at least. And do you know who else is a Yarny? Toxic Orchid. She is too. I haven't seen her lately. Excuse me, I'm yawning like crazy. Yo. United States have a total of 15 medals and Japan a total of 12. They have 6 gold, we have 3. As far as gold medals, we are now in 6th place. We got Japan, China, Korea, France, and Australia before us. But in overall medals, we're sitting at 15 with France in 2nd, Japan in 3rd, and China in 4th, and Korea in 5th, and Australia in 6th. Just thought I'd give you a little update. What do you think about this testimony? Yeah, he's got his glasses on now. He's serious.
Please.
What I'm showing you here is the 3D scan data of the scene. So I didn't take this data. This was done by Manatee County investigators. I took the individual scan worlds and then blended them together. This is a process called registration. And I'll move you through it. Hopefully we don't get a jump between my laptop and what we see on the screen. So again, this is not a computer game. These are actually millions of individual data points. You can see in some of these places the individual spots. Each one of those is a data point collected by the scanner. And as we look down on the scene here, you're looking at the sort of wood-looking floor. You can see a tape on the floor. And now I'm going to switch perspective such that we're going to slide down to the side to allow you to get a feeling for what we're looking at. So as I move through this, you're now looking towards the doorway, exiting the bedroom, over the top of the room.
Mr. Haig, I'm sorry to interrupt.
Please.
This is the room where the shooting took place.
That's my understanding. There are certainly fired cartridge casings, 4 of them in the room, as well as a bullet hole going into the wall here.
Okay, and that would be the mattress on the right-hand side that was leaning against the wall.
That's correct. Where I'm moving my hand cursor right here in the data is a mattress.
Okay. And are you able to, from that perspective, yet see the entrance to the room?
Yes, I can swing us around so that we look into the room even, if you wish. As I come down in the data, I can put us in the doorway.
Okay.
So that's a view into the room, and we can then even come into the room in that manner and pan around and see the room. Within the room, as I mentioned, we have a perforation into the wall, a nice round hole. As I recall, this is impact site 11 maybe, but if I swing around here, I can actually show you where that is. So the shadows you're seeing on the wall here are from the tools the investigators use. These are very common tools in our industry, trajectory rods. For this type of scanner, they often put a sphere over that rod, so that's why you see a round shape there as well. But the main point here is that there is an impact site in the wall right here. That's where a bullet hole exists. From that, I took 2 different approaches to create this trajectory for visualization for you. One, I simply took the scanned data, basically their trajectory rod in place, and looked at the many, many data points on that and extrapolated a line from it. If we use that method, the trajectory for that looks like this. So this is the blue line that comes out of that. And I'll swing you directly above it so you can get what's called the azimuth viewpoint first. I'm going to click us back into what's called an orthogonal view. So looking at this trajectory, you can see how as viewed, it has a slight left to right aspect to it, and it's traveling from the bottom of the screen as you're seeing it into the wall at the top of the screen. Now, the county investigators did a nice thing. They did 2 different ways with this trajectory, not only the trajectory rod itself, but they took the rod and then put a laser on one end and shined it across the room. So the bottom wall, as you're looking at it here, and measured where that dot was on the wall. So I simply took their data and connected the dots also. So between the perforation in the wall to their laser dot, and that line looks like that. So green and blue. In the trajectory world with walls, this is decent agreement between these 2 methods as far as the accuracy that we come to. And in fact, if I put plus or minus 5 degree cones, I talked about the error earlier, on both of these, we can see that those 2 cones look like that. That's actually a 10-degree cone for each of them, the green and the blue. And so from the data that I have for this case, for this one shot, I would include any area within that cone, either one of those cones, as the area where the firearm would have been at the time that shot was fired. I can also show you this from the side view to give you an idea of the vertical component. So I'm going to remove the left wall of the bedroom as you're looking at it here, and I'm going to swing you down.
Hey guys, this is what I live for right here. Y'all pay attention.
And from this vantage point, you can see how there is a downward component to these shots as well, going into that, I believe, again, number 11 hole within the bedroom.
Would that be consistent with Miss Benefield firing the weapon while she's standing in the upright position?
There are certainly multiple places along these cones where a shooter could be standing. So basically any hypothesis or any scenario that puts the gun in those cones, including that one, would be on the table. So we've seen the up and the down, the vertical component here. We've looked at the azimuth, the left and the right from above. What I'll demonstrate for you now with the data is I'm going to take you to the right.
If I may, Mr.
Please,
Hagan,
yeah.
As to that bullet, for the trajectory that you've just shown us, there was no indications that it had struck tissue. Is that correct?
That's correct. And I'll show you that picture of that bullet eventually. But this bullet, based on the damage that the bullet shows, as well as the nice round hole going into the wall, this is a miss of the decedent. This did not strike the decedent. If I take you to the side of the cone here, the far right side of the rightmost cone,
I'm still here.
most
I'm just giving you the full.
right option. From that position directly over it, if you look down the hallway area, you actually, there, they'll fill in, you actually cannot see where that bullet struck the wall. This area right here is to the right of the bullet's impact site. We actually have to move, as I will now, over into this area. And I'll get us right at the edge of the wall. We have to come all the way over here in order to get to the impact site, which from my examination of the images is more in this area. So somewhere on the tile in here is a bullet impact site, a ricochet off the floor. That bullet goes on and then barely perforates the drywall or penetrates the drywall up in this area. So
And that's another bullet, is that correct?
correct. Sorry, I'm on to bullet 19, as I recall, was its designator for those two.
Let me recap for just a minute. So
How many
one goes
bullets
in
did
the
she
wall,
fire? Did he just say
and then
19?
one goes down the hallway.
Or evidence?
That's correct.
19.
And again, you can't say which shot was first or second.
I don't have physical evidence that would allow me to establish that, correct? But that bullet in the wall down there also expresses no soft damage. It is also one that did not strike the decedent.
A miss.
A miss.
All right.
So from the 3D laser scan data, and I don't have a good trajectory or a good impact site to look at here. I was unable to go in and examine the floor. If I'd been able to find that impact site, I might have been able to refine that trajectory into the wall a little bit better and give us a more defined trajectory. But other than the ballistic accessibility aspect of going down that hallway, I can't do that here. Just they're two separate trajectories that have some slight divergence in the lateral aspect.
Did I ask you what the degree of accuracy is for trajectory reconstruction?
I think we covered that turf, just that plus or minus 5 degrees is an industry standard. And based on having shot a lot of stuff, including walls, for a trajectory like that, assuming the trajectory rod was placed properly, about plus or minus 5 degrees is appropriate.
Did you have an opportunity, Mr. Hagan, preparation for your responsibilities in this case to interview Ms. Benefield?
I wouldn't describe it as an interview by me. I was certainly present while she described the incident.
And with respect to her description of the incident, is there anything at all in your conclusions that was inconsistent with Ms. Benefield's description?
I can't think of anything that would necessarily be inconsistent. The key points that come to mind, where I remember her saying she stepped from her right to her left during the course of fire, that the decedent was moving rapidly in all sorts of patterns or manners, which would fit with the gunshot wounds entering the body in different angles. So from that perspective, no.
Give me just a moment, Your Honor, please.
Yes, sir.
That's all, Your Honor. Thank you, Mr. Hagan.
Cross?
I just have a couple of quick questions. So you were able to give opinions about where the trajectory would be for the two shots into the walls, correct?
That's correct.
But as for the injuries into the human, you cannot opine about that.
That's correct. I don't have any other sort of anchors to bring the decedent's body into play with the scene because of the lack of perforation.
And with reference to the chest wound, I saw you kind of turning it several times. So, and we've had terms used such as front and side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, and of course, I could refresh my memory with images if it's helpful, but to the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body
With the,
straight.
oh, this way?
Right. Can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes, I'd have no way of, yeah,
Thank
correct,
you.
yeah.
Thank you. No further questions.
Redirect?
No, sir.
Can this witness be released?
Yes.
Yes.
Sir, you're releasing your subpoena. You're free to go.
Thanks, sir.
Thank you. It's going to take him a minute to put that away, and it's about 10 minutes after 3, so I'm going to give you your afternoon break. Give you 10 minutes, go on back, stretch, get something to drink, maybe a little snack if you want it, and we'll get you back out here as soon as we can. Oh, no deliberations, don't talk with anybody about the case, and don't do any research. All right?
No, really?
Figured that'd be better than having you
hustle. Thanks, sir. Appreciate it.
All right, we'll stay in recess for 10 minutes.
Thank you.
Okay, guys. Side shot. Okay, you guys tell me what you think. What you think of this? Arr. It's so much to process. That I'm on the fence about that. Why do you put me back there again? You know, he did a great job of describing the projectile and the lead shooter and all that, but okay, let's talk a little bit about the hollow lead and the regular lead. A hollow lead is designed once the impact happens, it opens up, and as it's spinning, it causes more damage, slows down more in the body. So it goes in this flare, in like this, into the body, flaring. It will slow down the lead. It will definitely knock you around. It is? Is this better? Is this better? I was moving. It was a lead, a lot of force. So there were a total of 4 shots. She got 2 hits and 2 misses. So one of the things that I think I heard them say was something like side stance. But a side stance can also be this. A lot of times when people get ready to bow up, they don't do it square. A lot of times they'll step back, especially if they're going to throw a punch, they're going to step back. Here's your side stance right there. I'm not saying he did. I'm just explaining the physics. But poor Miss Jewel, she's frozen. I'm so sorry, honey. Do you know those little warmers that you can use? One-time use warmers that they put in their gloves and pockets. You can get those at Walmart. They're cheap. They'll keep you warm. It shouldn't be. Why are you getting sensei? Is it still crackling? I'm not moving it. Is it still crackly? Test, test, 1, 2. Buckle my shoe. 3, 4. Shut the door. Okay, I can't do that anymore. Okay, y'all. Here is a new advertisement from Hitchman Homestead Coffee. Hey, y'all, please help me welcome the Hitchman Homestead Coffee. They are fabulous. They have many different blends of freshly roasted, freshly ground coffee. They have a monthly club where you get 4 bags for $40 or a Keurig option. Also, they just came out with a half and half. Oh my gosh, I absolutely love it. So do me a favor. Go down to the link below at hitchmanhomestead.com. Order you some coffee and show them some love. And here is my new swoop. I'm not going to make it move, but I'll let you see it. There's my puppy, there's my kitty, and there's the monkey. The monkey was placed after fact, but everybody else was there. What do y'all think about that? I'll go, whoop. That'd be it. That my swoop. There's any movement where the mic will jostle it, but if you're explaining something, sometimes this connection will sound like that. I don't know. We're pretty anchored. Aren't they cute? My monkey butt. My monkey butt. That'd be my monkey butt. People wanted to know about my monkey. There she is. And my dog's getting ready to bark. Thank you. I think she's trying to get away from the puppy. You guys. We got a logo contest going on. Come on. We also have the Yeti. Oh, no, you're good. All my cables are pretty anchored. These are pretty, there's a clip here. You can't see it. It's off camera. Maybe if I make myself embiggen. I embiggen myself. These are clamped. So it shouldn't be making noise when it's moving, but it's all good. If it is, I need to go buy a new one. I can't buy these here. The ones that are here are too cheap. Oh my gosh, y'all. I am so fighting sleep. So fighting sleep. Unlike my interpreter who fell asleep. It's okay. Hey, I didn't embiggen my lips today. Someone said I had really beautiful full lips. My bottom lip is full, but my upper lip is really not that full when you look at it. I'll stop talking. You can see. See, the middle is kind of full, but I've lost that. I used to have more like that many years
I'm not sure
ago.
which one that was on. I think it was on
On the,
Young Mr. Galvano.
yes.
They're talking without scream. So anyway, I used to have him big in lips, but not no mas. The corners are shrunk to nothing. I went and managed all my cables because I had little critters that were breaking in. I don't know why.
Who's this
I-
last witness going to be?
This
Oh,
is Dr. Emma Lou, Your Honor, LEW.
Well, don't bring her in yet. I was just asking.
Maybe put another battery in. We're getting ready to bring in Dr. Emily.
While we're on the subject,
Emily.
how long do you think she's going to be? More than an hour?
Probably not. I would say maybe 45 minutes, my best guess.
No problem. I just versus 4 hours.
Correct.
All right.
No problem.
State, have you already deposed her?
Yes.
All right. So you know
Yes.
she's going to say,
Yes.
presumably what your question is going to be.
Yes.
I only ask because that will take us, assuming we start in the next, 5 or 10 minutes, 5 minutes, to 4:20. And I guess at that point, probably let the jury go
Not
for the
for
evening.
logo directly. No.
Well, you can announce you rest. We can let the jury go for the evening.
ASL
You guys can
needs to
say
be
if you're going to
part of the
call
logo.
any rebuttal or not, but then
Putting hands
maybe one pass
If I need to
to
send
the
that,
jury instructions.
I can.
I'd appreciate that.
So would I.
Okay.
Judge, the last thing the state wants to bring up is that, we didn't bring it up during the question, but I think that Your Honor had clearly
In Discord about
told
2
Mr.
minutes.
Taylor at the bench what he was allowed to ask Detective Warren. And that did not include, don't you find it odd that the state did not call you as a witness? And I think we had litigated close to that issue, if not directly on point, and then you directed him not to. And I know we're down to a few witnesses left, but it's been an ongoing attempt to subvert justice by Mr. Taylor to continue to do things like that, speaking when we've objected and continuing to speak. And as to the, don't you think it's odd, it was actually Mr. O'Keefe who told Mr. Taylor, hey, you need to object to this. So that's a whole different objection I have if Mr. O'Keefe continues to practice law in this courtroom. But I just think that at this point, the state is asking for you to sanction Mr. Taylor in some capacity about disregarding your continued rulings. And I understand that that may not be something we address right now, but it seems to be an ongoing issue in the state. That last one with Detective Warren was the most outrageous.
Okay. I'm not going to take that matter up right now.
Yes.
We got witnesses and other matters to deal with, so.
I just wanted to get it on the record before we move too far away from the witness. Thank you for letting me be heard.
Absolutely. All right, looks like we've got everybody back. Is Dr. Lou ready?
Yes, sir.
State, are you ready?
Yes, Judge. Thank you.
Sensei, seriously?
Do you need the?
I don't think so, Judge.
y'all can have a seat. Welcome back, everybody. Any deliberations, contact outside the jury about the case or research? Everybody says no. All right, Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Dr. Emma Lou.
Okay, Miss Sneaky Side, please go to Discord direct messages. I've left you a message.
Good afternoon, Doctor. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone, just to get a loud, clear voice. It does adjust up, down, left, right if you need.
Yes, thank you, Honor.
I may like your concept. I may have to tweak a little bit of it, but I like
Good
the
afternoon.
concept.
Would you tell us
I'll
your
use
full
it.
name and spell your last
You
name?
win. Doesn't have to be
Yes,
perfect.
my name is Emma Lou, L-E-W.
And do you hold any professional degrees?
Yes, I am a licensed physician in the state of Florida, so I have an MD degree.
All right, Dr. Lou. Let's
PhD.
take a moment. Let me just run you through your undergraduate education.
Oh, God, no.
Where did you receive that?
I graduated from the University of Saskatchewan College of Medicine in Saskatoon, Saskatchewan, Canada.
Following your college degree, you attended professional school?
I did a one-year rotating internship in Vancouver, British Columbia, and started my pathology training in Vancouver. I completed my pathology training in Saskatoon, Saskatchewan, worked for 3 years as a staff pathologist at the Royal University Hospital, then came down to Miami in July of 1991.
And with respect to your work experience, what brought you to Miami-Dade County, Dr. Lou?
I wanted to train in the best facility that there was for forensic pathology, and everyone in Canada and in the States said, go to Joe Davis in Miami. So I did.
And did you eventually rise to the position of the medical examiner for Miami-Dade County?
Yes, when I was in training, I was an associate medical examiner. Then Dr. Davis offered me a permanent staff position, and I was an associate for 10 years.
I want to ask you if you can tell us, if you can approximate the number of autopsies that you performed.
In Miami-Dade County, it should be at least 5,000.
As part of your duties as a medical examiner in Miami-Dade County, Dr. Lou, did you also respond to crime scenes?
Yes, we responded to scenes of violent and suspicious deaths.
Would you tell us why? Well, first, let me ask, is it typical for the pathologist to respond to crime scenes? And depending on that issue, why you chose to do so?
Yes, in Miami-Dade County, when law enforcement needed a medical opinion, whoever was on call as the medical examiner would respond. And the purpose is twofold. Number one, so that we can provide an opinion about the circumstances of death or the types of injuries on the body, and also for our benefit, so that I can see, or we can see, the body in the context of its surroundings and be able to better interpret our findings at the time of autopsy.
Do you teach any courses?
Yes, I used to teach in the medical examiner death investigation course, and I still teach for the Carnival Cruise Lines security conference, and I will be lecturing in the Miami-Dade Police Homicide Investigations course.
And how about gunshot wounds? Have you taught courses in gunshot wounds?
Not entire courses, but I have taught the section about gunshot wounds in death investigation courses.
Let's not take anything for granted. And if you'd be kind enough, would you explain to us, Dr. Lou, what is an autopsy?
Oh my God.
An autopsy is the examination of a dead body. It consists of two parts.
Sorry, guys.
One we call the external examination, and that's when we look at the outside of the body and describe such things as height, weight, color of hair, eyes, scars, tattoos, any evidence of medical intervention, that is, any evidence that paramedics or doctors and nurses may have treated the decedent, and then any evidence of injury. After looking at the outside of the body, both front and back, and in the orifices, then we do the internal examination. And that's when we open up the body cavities to examine all of the organs and tissues inside the body cavities, from the brain inside the head down to the pelvic organs. That is an autopsy.
Go place.
Dr. Lou, were you asked to assist in this case?
I believe I was, yes.
Would you tell us how?
I believe you contacted me.
And what did you do in preparation for your testimony here today?
I reviewed the autopsy report. I reviewed some of the autopsy photographs, and then other circumstantial evidence, as well as having spoken also with Mrs. Benefield.
Okay, I need you to try to keep your voice up. Did that include being present for Miss Benefield explaining what had happened?
Yes, I had made a previous trip to Bradenton and had met with Mrs. Benefield.
I'd like to ask you, Dr. Lou, about the gunshot wounds in this case.
Yes.
Will you tell us how many there were?
There were 3 separate gunshot wounds.
And would you please explain them?
Yes. One was a superficial gunshot wound on the right upper arm. And that we call a grazed gunshot wound. That was one of the gunshot wounds. Shall I explain the direction?
Please.
Now, you probably heard about pathways of gunshot wounds from Dr. Vega, but as a quick refresher, if, for example, a gunshot wound was from front to back and right to left, that is relative to the person shot, not to you, not to Mr. Taylor, but relative to the person shot. So if it's from front to back and right to left, it is coming in from the victim's front towards the back and from his right side towards his left side.
And was there another gunshot wound?
Yes, there was another gunshot wound on the right side of the chest, just outside of the right nipple. Please,
the
and yes, the pathway of that gunshot wound happened to be from front to back and right to left. And I'm sure Dr. Vega told you it just nicked the bottom of the right 5th rib, went through the right lower lobe of lung, then through the part of the spine, the bone of the spine, then the left lower lobe of lung, and then nicked the back of the left 10th rib.
And lastly, was there a third gunshot wound?
Yes, there was a gunshot wound. This time it was a through and through gunshot wound, or what we call a perforating gunshot wound, that entered the inside back of the right thigh, went through both right lower leg bones, and came out the outside of the right lower leg just below the knee. And that pathway was from back to front, left to right, and upward through the right lower leg.
Let me, if I may, using the easel, show you a picture and have you explain to the ladies and gentlemen of the jury, you mentioned that the abrasion wound to the arm, did you tell us what the trajectory was for that?
In my opinion, the pathway of that bullet was from front to back, upward, and slightly left to right.
Okay, so how, Dr. Lou, are you able to reach a decision like that on something like an abrasion wound?
Through experience and training, having had hundreds of gunshot wound cases and seen thousands of gunshot wounds and supervised hundreds more cases.
Okay, let me show you these two demonstrative aids and ask, with court's permission, if Dr. Lou could step down. I wonder if we could have the easel so I could set these up.
I'm not too sure I want to do this.
Dr. Lou, here is a pointer that will help you.
State, feel free to reposition as you need so you can see what's going on.
With court's permission.
Yes,
I
ma'am, you
ask
can step
Dr.
down.
Lou to
Thank
step
you.
down.
Beautiful hair.
State, have you already seen these?
Yes. Not until now, but I just saw them.
Okay.
You have preference of which one you'd like to start with.
Why are you just now seeing them?
This one. All right, would you tell us what that represents, Dr. Lou?
This is the graze or superficial gunshot wound on the outside of the right upper arm.
Hey, Jules, are you awake?
Yes, a rod.
Point of a rod on the knee.
We have 3.
Now, the reason I know that this is a graze gunshot wound is, from training and experience. Now, the direction of this projectile. You see, this edge is a little bit more rounded, and because it's a deeper red, I know it's a deeper part of the wound than here in the side. Now, as the projectile skips across the skin, because it's so superficial, it raises skin, it causes skin tears and raises skin tags. Now, there's some skin tags here, but the best one is this one right here. See this V-shaped tag? And for simplicity, how I remember pathways of graze wounds is that the skin tags point toward the gun. So if it's pointing in this direction, the gun is somewhere along this line here. So the bullet, therefore, is coming in this direction, going from front to back. This is the front, this is the back, going from front to back and upward. And because it's on this part of the arm, you can see it's slightly to my left, to my right. So this is from front to back, upward, and slightly left to right.
If I may.
While they're doing that, the men's gymnastics team got their
This is the
silver
gunshot
bronze
wound
medal.
we just spoke about.
One of
This is
5
how it's going
men's
front to
teams
back
ever
and upward.
medal
This
in
is the
an
right
Olympics.
nipple. This is the second gunshot wound.
Kudos.
But it's been a bit changed or altered because this back portion that's straight was an incision made by the doctors in hospital. So the gunshot wound itself is this round part. Now, this is the one that goes from front to back and right to left. The bullet was found by Dr. Vega on the left side of the back.
Now, there's something special about this gunshot wound that Dr. Vega may have told you already. After going through making the right fifth rib and the right lower lobe of lung, it then hits the spine. Now, the skull closely surrounds the brain and protects the delicate brain. The spinal cord is an extension of the brain, and the spinal cord is protected by the spine, which is made up of multiple blocks of bone. When a projectile cuts across the bone of the spine, even though it doesn't touch the spinal cord, the energy that is expended by the bullet impacting the bone is transmitted to the delicate spinal cord. And what this wound will do, because the bullet went across the bone of the T10 vertebrae, it causes a spinal cord shock. And the result is paralysis of the legs. I know because I've had cases like this where a bullet not even going through the bone of the spine, just passed by the side of the spine, caused the man to fall on his back, and he was heard to say, "I can't feel my legs." So that's something that's significant and important about this gunshot.
All right. I think you can probably return to your seat if you like. Does it have some water in it?
It does. It's too complex for me.
MDs can't figure out how to turn on a water, turn the spout, hold it. Oh my God. Oh my God. That was real funny.
Dr. Liu, did you have an opportunity prior to your testifying here today to meet and observe and listen to Miss Benefield explain the events that took place on that day?
Yes, I did. It may have been last year that I did that.
Is there anything at all with respect to your findings that is inconsistent with the explanation Miss Benefield gave?
I believe that Mrs. Benefield's account is consistent with the evidence on the body, and I can demonstrate that.
Don't.
At the time that you observed Miss Benefield explain these events, did she know what the actual physical evidence was, the actual
Objection.
forensic
Hearsay,
evidence?
If she can answer without speculating.
I do not know. However, usually the person doing the shooting does not know about the autopsy results. And even if they got the autopsy report, they would need someone to translate the autopsy report for them. So I doubt it, but I am speculating.
Were you struck by the explanation you received in light of that?
Objection relevance.
I'll sustain.
One last question, Dr. Liu, if I may. How many times, if you can approximate, have you appeared as an expert pathologist and testified in court?
During my career, at least 500 times, and then maybe 20 some times more after I retired.
And the vast majority of those occasions, did you testify for the defense or for the state?
Most of those times I testified for our state attorney.
I have nothing further, Dr. Liu. Give me just a moment, Your Honor. Dr. Liu, would it be helpful if I were to volunteer my law clerk to come up and allow you to show with the trajectory rods the wounds that were sustained by the deceased?
I believe it would add a new dimension to my testimony. Yes.
Okay. Judge, with your permission, may I?
Yes.
Come on up, Will.
May I step down, Your Honor?
Yes, ma'am, please do.
May Dr. Liu step down?
Now, I believe that the Gray's gunshot wound was the first gunshot wound. Ms. Benefield indicated that Mr. Benefield was coming towards her. Objection, Judge.
I'm going to sustain.
Very much.
Go ahead, Dr.
Very
Liu.
much
You
so.
just can't say what Ms. Benefield told you,
Okay.
just based upon your conclusions.
I believe the first gunshot wound.
And I would object to that opinion, Judge.
I'm going to need you to approach, please.
Yeah. Y'all. What the baby girl? Don't you pull away from me. You get over here. You came up and sniffed me, wanting my attention. And then you walk away like that? Gee. Please. She's like, Mommy, Mommy, Mommy. I'm like, what? My little girl.
Dr. Liu, without regard to anything that Ms. Benefield may have said that you heard, based upon your expertise and your own conclusions that you've reached, do you have an opinion as to which one of these shots may have been fired first?
I believe that the right upper arm Gray's gunshot wound was the first shot.
Are you able to say why, what independent evidence exists that leads you to that conclusion?
I have based my opinions on the circumstances provided to me.
Okay.
Microphone.
And would that be consistent, the upper right arm wound, would it be consistent with the bullet that went down the hall, for example, and lodged in a book?
Yes, it would be, because it didn't go into the body, it just went across the skin. So the bullet would be free to continue on into another room.
Okay, and because it is just a graze, it would not have any tissue effect or mushrooming, as they say, correct?
Objection, objection.
If she can testify to that from her knowledge and experience.
Because it only grazed the skin, nothing went into the hollow point nose of the projectile to cause deformity or mushrooming of the projectile. So it would be more or less pristine.
All right. Now, you've told us, Dr. Liu, about the shock to the spinal cord from the shot that entered the chest.
Yes, going from front to back and right to left.
Would that have, in your opinion, affected Mr. Benefield's ability to stand?
Yes, as I explained earlier, it would cause a spinal cord shock, causing paralysis of the legs and causing Mr. Benefield to fall.
And in falling, would it be consistent that his legs would go up in the air almost as if he slipped on a banana peel?
Yes, that would be consistent, and I can demonstrate.
Please.
This is,
The right side facing the
Judge, with the court's permission, could the jurors perhaps stand so that they could see this demonstration?
Judge, I'm confused as to what we're demonstrating.
okay, I want to say something here. You can do this all day long. There's no dispute that she shot him. But was her shooting him a equal answer to his action? Meaning, was her fear truly that great that she had to shoot him? Or basically, is it self-defense or not? We're not denying, neither is she, that she shot him where and when she shot him. It's the matter of, was she truly in danger of losing her life? Thus, she had to take a life. That is the issue.
We're demonstrating the shot to the leg.
Oh, the shot to the leg.
Yes, sir.
Okay, folks, if you need to stand to reposition yourself.
Now, the entrance was on the right side. The entrance was on the right side of the back of the cab.
There were 2 bullets that made full contact. One made a graze, up out of 4, at least.
See that the gun would be somewhere along here. So
And
you
for
can see
me,
how consistent this
the way he's spinning,
would be.
how and why she kept
From
pulling
getting
the trigger,
shot
I
while
don't know.
on the ground.
That's what I want to know right there.
The gun being
One shot
consistent.
should have been enough, the first one, to get out of it.
Here,
Not
coming out
bang, 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 bang.
Okay, so this would be, in effect, a snapshot in time.
Yes, it happens very quickly.
All right. And would it be consistent, Dr. Liu, with the shot to the chest, paralysis, Mr. Benefield falling backwards, his legs going up in the air, and another shot going through the leg?
Yes.
All right.
The evidence on the body that consists of those gunshot wounds is consistent with that.
All right, thank you very much. Thank you, Will. I have one last question for you, Dr. Liu. You can take the witness stand. Do you recall whether there was any other injury to Mr. Benefield that would be consistent with his legs going up in the air and him falling backwards so that his head would hit a tile floor?
Yes, Dr. Vega found an abraded contusion on the back of the head. A contusion is a bruise. An abraded contusion means that there's a little bit of scraping of the skin or crushing of the skin in the center of that bruise. That is entirely consistent with Mr. Benefield's back of the head striking either the wall or the floor as he fell on his back.
Thank you very much, Dr. Liu. I have no further questions.
Oh, come on, defense. Prosecution, let's liven this up a little. I'm good. I'm here for some spice.
I just want to ask you about the leg wound.
Yes.
For a moment.
Yeah.
You're not saying that that is the only position that he could have been in, are you?
No, I am not saying that.
Okay, so there are other positions that maybe could have produced that wound path.
Yes.
Okay. The one that you are describing is just one that is consistent with it.
That is correct.
And when you said his spinal cord would be, I don't know what you said, shocked? maybe?
Yes.
Concussed, I don't know what you said. And his legs would go paralyzed.
Yes.
Does that
Mhm.
normally
Yeah.
mean that they stiffen, they straighten? Does it mean they crumble? What does it mean?
Different people react differently depending on the position that they're in. And paralysis usually means just not being able to move.
Okay, so depending on maybe what movement they're doing at the time, that's what they're gonna continue to do.
Possibly,
So,
yes.
possibly. So if he is walking towards someone, we fall backwards with paralyzed legs?
Well, we weren't there, so I don't know exactly his body positioning and movements.
Okay.
But
And you spoke about the
not
abraded
realizing.
contusion on the head, and that can be consistent with falling.
Yes.
From a gunshot. Can it also be consistent with being drug out of the house by EMTs?
Not unless that part of the head were to be struck on something, because the contusion is a bruise which requires blunt force.
Right. So if, for instance, he was being drug out and hit the door jamb or something, bounced his head, could it have caused that kind of abraded contusion on the head?
Yep.
Well, done with enough force, that is possible.
Okay. Thank you. No further questions.
One. Dr. Lou, would the abrasion wound to the right arm of Mr. Benefield be consistent with him lunging towards Miss Benefield?
Nope. You can't tell that. She can't say.
Remember, the pathway is from front to back and upward. So if he was lunging and you were the shooter, you can see how that would be consistent.
That's all. Thank you.
Do you have any questions on that?
disagree.
All right, can this witness be released? Can the witness be released?
Yes, sir.
State? Ma'am, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Thank you very much.
So I agree with some of her testimony, but you can't say infinitively any of that. She can't. She wasn't there. You can show path and like through the chest, you can show somewhat of a
Mr.
path
Taylor?
arm, but to say that's the
We
only one.
have this one issue left.
Okay.
They're going to rest today.
All right, members of the jury, there's a legal argument I need to take up. If you could step out for about 10 minutes for me, we'll do that, then we'll bring you right back. No deliberations, no communicating with anybody about what we've talked about the case, and don't do any research on any of the issues. We'll get you right back in a minute.
Guys, we've had to drag people out of tight rooms, couldn't get the gurney in, so there's a sheet with handles that we slide under them and carry them out. Sometimes the arm falls out and they nick the wall with their arm because you're moving quick to try to get them into the unit to continue life methods and procedures. So,
Okay, oh, you all can have a seat. The jury's out. And was this the issue, the Richardson?
No, this is the DNA issue.
Oh, yes.
And I have the following case for the court. Ladies.
Thank you.
I hope he pays his paralegal well when we don't get paid well. Because it looks like he's done a lot of work. But I can tell you the lawyer isn't doing all that work. Oh, God, I hope so too. I don't think we're going to get 100% innocent. I think it'll be either guilty or hung. I don't even know if they're paying attention to that. I hate it when people do things offset like that. It just, I'm more balanced. Yeah, he is putting in the work. Hi, Erica. How are you? Thank you for joining. Oh my gosh, he's putting in so much work for this case. I hope that he has another paralegal. And this is just the one that goes to court with him. Hmm. God help us. You've been lurking? Anything you have to say about this trial today? Nothing's really hit home for me. I mean, Emily is, it depends on what side of your fence you're on. She could be convincing, but it frustrates me when they sit there and talk about something being absolute when it's not absolute. Yeah, right? I'll be right back, y'all. I accidentally squirted puppers with my perfume, and she's going, Okay, I'm not going to say where I actually stand, but if you stand on the fence, I think a lot is getting lost in this trial. The whole point of this trial needs to be one thing only. We don't need to worry about the ME and the evidence. She shot him. She said she shot him. The whole thing needs to be what was the did she feel that her life was in such a threat that she had to take a life? That is where I am. I don't envy a jury on this one either. You're right. Undecided equals not guilty beyond reasonable doubt. But what I'm saying is that there's a lot of rabbit trails in this case that they've tried to go down, but the end of all decision is intent. Intent. Did she really believe that he was going to kill her? And if so, she took drastic measures. Yeah, she does. That's true. But a lot of people do. So that's for me. I'm going to put another poll up. starting a poll. Whoa, our numbers have changed. Let's see who takes the poll. You can take the poll. You don't have to comment for all who are watching. But, I also know how quickly you can discharge. Up, 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 up. That was 5. Up, 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 up. So 4 would be up, 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 up. Up, 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 up. That, as quick as you can pull it. So if she was just pulling it and just doing this with it. But she's been to training, and here's where I'm frustrated with this case. She's been to the lead shooter training for a license. And in that, they teach you not only how and when to use the said lead shooter, but also you go through of a conflict resolution as well. You can't be in a conflict with somebody who's just screaming and yelling and, boasting and going off and then say you're in fear of your life when that's not an equal reaction. When you go through that training, you go through examples of when to pull and when not to pull, and nothing she has said in this case would have me in that training saying pull it. She'd get the question wrong. And when you have a license to carry, you are held at a higher standard because you've gone through training.
Go ahead, sir. I've had a chance to review shorter.
Okay, so this was a DNA report, precisely what the circumstances are here. The state initially wanted to introduce it, but then changed their mind because it didn't have any inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, the appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor. So I can't imagine that the state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody. So we think that the shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
I thought I made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. The fact that those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in property evidence. That's all. We don't have any evidence that the same swabs that she was collected then went to DNA labs. And that's what you have to lay the proper foundation. And this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections. Because my objections are what I've already stated, but also 403, just that lab report in evidence. This is very confusing. It's DNA. And it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where those swaps came from, all those things. And I think that would be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents, and that there hasn't been an adequate foundation and that they're confusing.
Sure. Any rebuttal?
Yeah, so the court recalls that Detective Warren sent the swabs to the lab. Megan Dorvac testified that she swabbed Miss Benefield. I asked her why. She said because it would show who had touched her. The court should recall, consult your notes, Your Honor. Miss Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times more likely. We think it's an essential component of our defense. Now, we don't have any, chain of custody is irrelevant. Even though they've just basically undermined their own chain of custody, it's not an issue. It's the result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these two sentences, if I may.
Thank you, because I haven't seen this. Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is, what I've been handed is not marked as an exhibit. It's a 5-page document from DNA Labs International. It actually, it's a letter or report to Detective Justin Warren and a sergeant at the Manatee County Sheriff's Office. And it is signed by Jerome Rem, R-E-M-M, forensic DNA analyst. It lists a number of items. $14 different items that were apparently sent to DNA labs for DNA testing. And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880, swab from suspect's right hand. And it says that the testing was done. Mixture of 2 individuals, at least 1 male contributor. And it says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile.
I don't have my radio on, and there's been a lot of fire department movement. We had a shooting last night.
And it gives, based on its testing, two different propositions that were considered to explain the results. One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashley Benefield, Doug Benefield, and two unknown persons than if it originated from Ashley Benefield and three unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and two unknown persons contributed to the profile rather than Ashley Benefield and three unknown persons.
So I would ask you to read that next.
I am. I'm reading it as I go.
Okay, thank you, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if the sample originated from Ashley Benefield and three unknown persons than if it originated from Ashley Benefield, John Sant, and two unknown persons. Therefore, there is extremely strong support that Ashley Benefield and three unknown persons contributed to this DNA profile rather than Ashley Benefield, John Sant, and two unknown persons.
What if her and her boyfriend, maybe John, at the time, got in a disagreement and he smacked her and she used it towards Doug? You guys, I've seen it.
The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison. All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why the standard we usually see is one of the parties, whoever it is, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab. Then the DNA lab analyst will say how they went and got it. And I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish
We need to get
evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
I would demand that baby's
Isn't
DNA.
that when the defense contests?
In the problem, well, I gave everybody the chance to argue. So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision. However, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the fourth DCA, it says so in the very next paragraph, the reason the fourth DCA upheld the admission was for that very reason, that the state did not argue 403.
No, but that's a good twist.
And here they are.
Twist.
Here the state has argued the 403 for a jury to understand what these mean, what these findings mean.
Got to have an expert come in.
I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says, and be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then what does it mean, the very strong support?
That is.
And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this, you said two sentences. Yeah, these two sentences that are highlighted.
Correct.
But that's only one of the two sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared. So, I mean, I have significant concerns about the misleading of the jury by putting this in.
No, they took the DNA off her arm.
It would, if it would.
There were other DNAs mixed in. 2 other people. What they call contact DNA. But they didn't test the baby, and they didn't. And then they compared it to his, and I guess a John. Here's the contact info for John. I didn't ask it. It just went off.
So, no, sir. Based upon the request that's before me, which is only to put in and read into evidence these 2 sentences regarding one of the propositions that was considered by DNA labs and interpreting their test results, certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes.
As a
I'd
proffer?
like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
29, but this is the whole record.
Well, hold on. You're handing me a stack of paper that's about, what, 1.5 inches tall?
Yes.
And the only thing you said you were going to enter was this 5-page.
Well, no, I said the only thing I wanted to enter was to read those 2 sentences. This is the full report.
All right. So it would be your intention to admit into evidence Defendant's Exhibit 29, Is this in here or does this go in here?
Yeah, no, that I believe is in there. This comes back.
His voice. Wow.
Oh, I'm sorry, Ron, I stand corrected. This goes in with the report.
I'll let you put it where you want it.
Can I make a proffer for the record?
He's got a bad cold, so
Yes, absolutely.
All right, thank you.
Oh, wait a minute. Beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer as to precisely why I think it should be admissible.
Yes, sir.
Okay, so unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence. In this instance, Judge, we believe this DNA report is exculpatory. And we believe it's exculpatory because it confirms Miss Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Miss Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashley Benefield, Douglas Benefield, and two unknown persons than if it originated from Ashley Benefield and three unknown persons. Now, maybe I misunderstand this, Your Honor, but to me, what that says is there's 720,000 times more probable that Doug Benefield touched Ashley Benefield's hand. That's what I believe this says, and that's what I think we should be entitled to get to the jury.
All right, thank you. Where do you want that right after the first page?
You can put it right on top.
It'll cover up the exhibit number then.
Oh, okay. Yeah,
So I'm just putting it right behind it. And as I said in my ruling, I think that those questions and what that means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the 4th DCA recognized, not having that analyst causes significant 403 problems with confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow? And it would have to be by Zoom.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen. So
Jules is
I just
in
we need
there.
to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court abate the proceedings so that we could call the analysis. If the court denies that, then we will rest.
All right. Well,
All right.
There's Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect. It was just substantially, I'll say substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
So do you have a,
We'll rest.
okay. Let me bring the jury in. I will, we can do that, then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with the 9 o'clock start.
Wow. Defense rest.
Judge, just so you know also, we had submitted, the court may recall, you requested copies of the proposed homicide charge. And we had submitted our version to you that we thought would be appropriate. And I did not save a copy of it, so I wonder if the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it to Your Honor.
Since they quit.
Welcome back, everybody. Y'all can have a seat. All right, anybody do deliberations, talk with anybody outside the jury, or do any research? All right, everybody says no. Mr. Taylor?
Yes, Your Honor, Ms. Benefield has no further witnesses and we rest on her behalf.
All right, so folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out, and we'll have the deputies come down and get you as soon as we're ready and bring you up and get started. All right, remember the rules for tonight. Don't talk amongst yourselves. Don't talk about the case with anybody else, and no research about people, places, things, or legal topics. Thank you. Have a good evening.
Okay, the defense rests.
Y'all can have a seat. All right, I'm going to have to give you all, let me give you guys a 5-minute break. I'm going to go upstairs, and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs and see if I can find.
Clip.
Yeah, it was, yes.
And I have the state's proposed jury instructions and the standard for self-defense that changed in May, and I just wanted to include it.
So you got the new one.
Yes.
All right.
But I brought the standard because the instructions are very different than they used to be, so I just brought an extra copy. So
And you get an extra copy for.
Yes.
So 5 minutes. I'll be right back down as soon as I check.
Thank you.
I wonder if Jules is already headed home. Okay, y'all. So
Letter or report, DNA.
I want to hear something real quick, guys. Sorry.
Welcome back, everybody. Y'all can have a seat. All right, did anybody do deliberations, talk with anybody outside the jury, or do any research? All right, everybody says no. Mr. Taylor?
Yes, Your Honor, Ms. Benefield has no further witnesses and we rest on her behalf.
All right, so folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out, and we'll have the deputies come down and get you as soon as we're ready and bring you up and get started. All right, remember the rules for tonight. Don't talk amongst yourselves. Don't talk about the case with anybody else, and no research about people, places, things, or legal topics. Thank you. Have a good evening. Y'all can have a seat.
So let's see what they do here. We're going to sit here for a quick minute and see if they do anything else. So tomorrow will be jury instructions and closing arguments. That is what tomorrow we're gonna stop sharing that. My thing's going a little weird. Sometimes it can happen. Why are you doing that? My internet, my page layout's freaking out. That's weird. Well, okay, guys, it looks like that's going to be the end of it. They're not going to do anything else. If they do, we'll hop back on. But in the meantime, y'all, thank you so much for joining me. It's been an interesting trial. Learned a lot. Look forward to closing arguments. We'll be doing some interesting. Oh, poll is 50-50 on guilty, just so you know. So I'm going to say right now, I think we may have a hung jury, but that's in my own humble opinion. Yeah, I know that doesn't mean a whole lot, does it? But everybody, thank you so much for joining me. Go hug on your loved ones. And remember, we all have a bad day. So if you're out in public today and you see someone being not very happy, smile. Maybe the only one they get all day. I'll see you guys same time, same place tomorrow. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.